matter not before the lordship may last Monday I have mentioned my list for listing of the matter. For modification of the order. Your lordship direct list the matter today, but it will not be listed. Monday
Yes.
My lord, item 82, not please listed today, please. Taken
80?
today. Take 82. Taken today. 4 week list has reached only.
No, mention the matter if any urgent matter after 100. Otherwise, I will go serially first. Okay, yes.
Pardon me, my lord. CRL 46318. My lord, tired of matter, my lord. Can you list it to
Side of 12, my lord.
Item 100, my lord.
Yeah.
Pardon to mention, my lord, item 100. I'm appearing on VC, my lord.
Please keep.
No, item 107. In a appeal out of 10 years, 9 years already custody. Other list. Other person religion. 6-7 item.
Item 104, my lord. Remain in jail.
All right.
Yes.
My lordship, item 100, my lord. My
Yes.
lordship, being listed for 2 weeks, but it has not been taken up. Meanwhile, the two accused who were in
It will be
custody.
taken up at 2 o'clock. Okay.
Yes, my lord. Much obliged.
All the matter serially.
Supplemental list item number 1.
My lordship, in this matter, I am through VC. I am seeking the kind permission of my lord to appear in this matter. Lordship, in this matter, I have got a call from the local lawyer, advocate, that some notice has been received, but the party has informed me in the morning also that he has not found any notice as yet. But if my lord permits, I would like to appear in this matter, although the filing of Inama will take some time, lordship. Since I am in Delhi and he is in Odisha state, so just to get his sign and to submit in the court will take some time, lords. And in this case, at present, out of 4, all are on bail, lordship. And so far as the present accused is concerned, no amount of ganja was seized from him, lordship. And he was in jail for more than 3 years, lordship, at that time of the interim bail. And now the trial is at the stage of 313 has been done. So matter is listed for the final arguments as per my information.
Anything further you want to say?
Lordship, no, lordship.
Okay. Order will be passed. Yes, next.
Item 12.
Yes, I'm not. No, I will pass the order. Yes.
Item 2, let's have a glance to order dated 19/7.
Yes, now
I have filed my reply. The lordship have a glance to my reply, para 4. The reply, my lord, flag R.
so let it be examined by the trial court at the while accepting the bail bond if he is found to be. Yes, Mr.
Yes, your lordships. Yes, your lordships.
That would be better. Why unnecessarily? So
Yes, your lordship.
case at all, just refresh the memory. You are in custody since when?
I'm in custody, my lord, since 6/3/2018.
6/3/2018.
2018.
Yes.
Lord, if your lordship kindly have a glance to my affidavit, I have Lord given the order dated 21/7/2023 passed by the Honorable Supreme Court.
20?
Annexure 6, your lordship can see. In my reply, flag R.
Hmm.
Annexure 6, page 5.
Hmm.
One of the co-accused, that Lakhan Soni,
Hmm.
has been granted bail by the Honorable Supreme Court.
Hmm.
While granting bail to the Honorable Supreme Court, Honorable Supreme Court has specifically said, out of 164 charge-sheeted witnesses,
Hmm.
22 witnesses have been examined,
Hmm.
and on the ground of delay in trial, the Honorable Supreme Court has allowed the prayer for bail of Lakhan Soni.
He is a co-accused in this.
Co-accused.
Okay.
He's in a different
Head of
footing.
the accounts head.
Okay. So far, this order was passed in 21/6/23.
23, my lord.
So what is the position now?
Now, my lord, status report has come.
Yeah.
From the status report, it reveals that 37 witnesses have been examined, and CBI has filed a memo that he wants to examine another 55 witnesses.
55.
My lord.
More witnesses. Okay. So since 6/3/2018, you have never been released on
No.
either interim bail or anything like that.
No, no.
Okay. So it is more than 6 years. And this accused who has been granted bail by the Honorable Supreme Court,
My lord.
he was in custody for what period?
That, my lord, he was also in custody 6/3/2018.
Let us see that order once again. এই যে ଦେଖଉଥିଲେ ଯୋଉଟା annexure 6 ଲକ୍ଷଣ ସୋନିର କେବେଠୁ ଲେଖିଛନ୍ତି? Acha, he was arrested on 4/2/2019 after you. Okay. That is
No,
mentioned
my
in
lord,
that.
the appellant was arrested 4/2/2019.
Kiye?
4/2/2019, my lord.
ଆପଣ 6/3/2018 କହିଲେ?
My lord.
6/3/2018
No, no, ସେ ଆଜ୍ଞା custody 4/2/2019.
So 4/2/2018 same date ରେ ଦି ଜଣ ଯାକ ହେଇଛି।
ନାଇଁ ମୁଁ ଆଜ୍ଞା ଅଛି 6/3/2018 ରୁ।
ଓ ମୁଁ ତ ସେଇଆ କହୁଛି।
ଆଜ୍ଞା।
So you are in custody since 6/3/2018.
18.
Lakhan Soni was in custody since 4/2/2019, right?
And another director has been granted bail by this honorable court. I have given my lord, I have furnished my that order.
It's all right. The Honorable Supreme Court has granted. Heard the learned counsel for the petitioner, learned counsel, learned special public prosecutor, Mr. Nayak for the CBI. As per the order dated 19/7/2024, Mr. Pradhan has filed the reply affidavit. Reply affidavit na kaun sa file karte?
And a counter.
Reply to the counter affidavit filed by CBI. Stop. He submits that the petitioner was taken into judicial custody on 6/3/2018. And when he approached this court for bail, where is the order of this Honorable Supreme Court? No, that is not the above.
Once his bail application was dismissed, your lordships.
Huh?
Once his bail application was dismissed, Abhishek Singh Chauhan on 27/2018.
No, this Honorable Supreme Court order टा होची annexure 6 କହିଲେ ପରା आपण जोटा रिमांड करिक आनथिले ना कोन ये अप्रोच कला पर सुप्रीम कोर्ट को
नहीं, ये सुप्रीम कोर्ट जाएंगे।
आपण जाई ना सुप्रीम कोर्ट
ना 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 मु सुप्रीम कोर्ट जाय।
अब बेल कहा रहितला जो इंटरिम बेल कोन कहउथिले का
दीटा आगे ऑर्डर देछि लखन सोनी has been granted bail.
Yes.
Another co-accused, that order I have also furnished that, my lord, also kindly see page 7. Ashish Chauhan order.
So far as this petitioner is concerned,
My lord.
earlier is it your first application or
No,
earlier
this
you
is second application. First application was withdrawn.
Where is that
That
BLF
I have furnished memo.
Also, the bail application number 4904 of 2018. I remember. 4904 of 2018.
4904 of 2018.
My lord.
Dismissed on 27/2018.
It was withdrawn.
Yes, it is.
अच्छा लर्निंग तापर लिखिबे लाइन कौन लिखिले पढ़ले 6/3/2018 he approached this court for the first time in BLAPL number 4904 of 2018 which was disposed of as withdrawn by the order dated
20/7/2018
27/2018 तापरे आउ एठिकी
ना तापर
आउ ऑनरेबल सुप्रीम कोर्ट को
ना
मध्ये
सीधा
जायना
भी जाए
he submits that thereafter neither the petitioner approached this court nor the honorable supreme court he submits that and a co-accused namely Lakhan Soni who is similarly situated has been granted bail by the honorable supreme court na? In criminal appeal number is it 2060 na kon 2060 of 2023 as per order dated 21/7/2023 mainly taking into account his period of detention in custody since 4/2/2019 and the slow progress of the trial. Peru, the order passed in the case of Lakhan Soni, which reveals that submission was made by the London ASG on instruction that out of 164 witnesses, 22 witnesses have been examined by them. The London Counsel for the petitioner submitted that at the present stage in the trial court, out of 164 witnesses, 37 witnesses have been examined, and a memo has been filed on behalf of the CBI that the prosecution is to examine 55 more witnesses. London Counsel further submits that another co-accused, namely
Lakhan Soni, he said.
ନାଇଁ ଲକ୍ଷଣ ସୋନି ତ ଗଲା ଆଉ ଗୋଟେ କିଏ ଯାଇଛି ବୋଲି କହୁଛନ୍ତି
Ashish Chauhan, he said, your lordships.
No, 183 lots of my brief
183 page ର
that
Yeah, our bail application lordships has been dismissed by the Supreme Court. Video order dated 27/2/2019.
no ସିଏ ତାଙ୍କ ସବମିଶନ ଟା ନୋଟ ହେଇଛି ଆଉ କିଏ ଯାଇଛନ୍ତି ବେଲ୍
again
କହୁନାହାନ୍ତି ନା କଣ କେତେ ନମ୍ବର କୁହନ୍ତୁ
that not
ଆଭରମେଣ୍ଟ ନେଇଛନ୍ତି ବେଲ୍ ଆପ୍ଲିକେସନ ରେ
ଦେଇଛି order ଟା
Your lordships, bail application number 9441 of 2019. Prabal Pratap Singh was the CEO.
994
The Khojantuni 9441 of 2019.
9441 of 2019
19
ନା କଣ
Out on 4/1/2021.
ପ୍ରବଳ ପ୍ରତାପ
मतलब
ପ୍ରବଳ
Pratap Yadav ne, Pratap Singh.
ସିଂ ୟାଦବ ଆଚ୍ଛା ଏଠି ବେଲ୍ ଟା କି ଏଇ କୋର୍ଟ ରହିଛି ନା ଅନରେବଲ ସୁପ୍ରିମ କୋର୍ଟ ରେ
Honorable Justice BP Rautray.
ଏଇ କୋର୍ଟ ଆଚ୍ଛା ଭାଇ ଅର୍ଡର ଡେଟେଡ
4/1/2021.
4/1/2021 right all right he further submits that another co-accused namely Prabal Pratap Singh Yadav has been directed to be released on bail by this court in BLAPL number 9441 of 2019 by order dated 4/1/2021 na 4/1/2021 he submits that in view of the delayed disposal of the trial and since the petitioner has remained in custody for more than 6 years and similarly situated co-accused has been released on bail, the bail application may be favorably considered. The Land Counsel for the Special Public Prosecutor submits that the bail application of some of the co-accused ଜଣକର ନା କେତେ ଜଣକର ରିଜେକ୍ଟ ହେଇଯିବ କହୁଛନ୍ତି
Ashish Chauhan, your lordships, bail application number 7649.
we submit that the bail application of co-accused Ashish Chauhan has
Was
been
dismissed.
rejected by the Honorable Supreme Court. ଆଉ କିଏ କାର ରିଜେକ୍ଟ ହେଇଛି ନା ନାଇଁ ସେ ଗୋଟେ
Full Singh, your lordships, Full Singh.
ବୁଲ
Your
ସିଂ
Again, Full Singh A6. Your lordships had granted interim bail. He has absconded.
ବୁଲ ସିଂ ନା ଗୁଲ ସିଂ କ
Full Singh.
PHUL
HOOL.
ହଁ
PHOOL माना
अच्छा PHOOL submits that ना लिखिले आशीष चौहान बाकी लिखूँ is further submit that Phul Singh, who has been granted interim bail, has absconded.
And your lordship, the bail application of another co-accused Niranjan Saxena
Yes,
was also dismissed by this honorable court.
and one co-accused, namely Niranjan Saxena's bail application, has been dismissed by this court. है ना? Considering the submission made by the learned counsel for the respective parties, taking into account the period of detention of the petitioner in judicial custody and slow progress of the trial, and since similarly situated co-accused, namely Lakhan Soni, has been directed to be released on bail by the Honorable Supreme Court, I'm inclined to release the petitioner on bail and subject to condition Jota Pakeve and local sureties, two local sureties. The documents of two local sureties shall be properly verified. So also, a address ta verification है यही था ना?
हाँ verify ହେଇଥିଲା.
अच्छा, since the address of the petitioner has already been verified through the Learned Special Public Prosecutor, there is no need for address verification. However, it will be so for local sureties and concerned, the Learned Trial Court shall verify the same, है ना? Before accepting. Okay.
So
Yes.
free copy of the order may be provided.
Free copy.
Item 3.
May I, my lord? The item 49 is a personal reference to IAC.
Item
49, my lord.
49. Council till
Council 49. 49
Sir, may I please the lordship counsel through VC by person.
14 क्या ना सी से BC ଅଛି ନହେଲେ item 3 ଟା ଖାଲି 3 weeks after trial file deposition
49.
my lord ସେ evidence ପାଇଁ ଥିଲା
Just a minute. Let us see that. Last order was passed when?
last order my lord
It is passed on my lord on dated 23/4/2024.
So and so virtual mode. In spite of the order dated, the injured Brahmananda Sahu has not been examined in the trial court. There was a direction to the said in the said order to the inspector in charge of Dhannupali police station to appear before the Learned Trial Court, receive summons in respect of so and so. In spite of such orders, since the injured has not been examined, let the IIC Dhannupali police station file so was okay. So what has happened, whether that witness has been, Brahmananda Sahu has been examined in the meantime? Okay. Now, the IIC is present. What is your good name?
Sir, Ranjan Kumar Biswal.
Ranjan Kumar Biswal, Inspector in charge of Dhannupali Police Station, present through virtual mode from virtual High Court, Sambalpur लिख देवे, है ना? As per the order dated 23/4/2024, huh? The Learned Counsel for the petitioner informed this court that the witness injured witness Brahmananda Sahu has already been examined in the trial court. So where is his evidence copy?
Submitted before the honorable court.
You have already submitted. Okay. The personal appearance of IAC is dispensed with.
we have not received the deposition copy. Deposition copy we have also not received.
Mr. Counsel, you have not given the have you filed it for the court?
Lordship on 16/7/2024 they received it. The prosecution already received it on 16/7/2024.
Verify the record.
No, sir.
Is it available?
Not available in the record.
I have already
आनिबो ना नहीं पुनी तो
ଚଉଦଟା ସିଏ ଅଛି I have to file also.
If it has been filed online, so it should be brought on record. No. So far as court is concerned, is it? Have you filed for the court?
Yes, I have filed through online, my lord. Through
In
Sambalpur
the court or in the AG office you have filed for?
AG office, my lord. On 16/7/2024, they received it. I have the,
All right, but for the court you are to file or not?
yes, for the court.
Why have you not filed?
Sir, for the court I have filed.
Okay.
For the
Just-
code you file in the AG office.
Yes, well, in our e-filing, I have filed it. On 16/7/2024.
You have to file in the court website, not in
court
AG
website.
office. AG office
No,
for
no,
the
sir, let me, sir, for a second, sir. Here there is a provision of e-filing where the collectorate staff already received the documents and send it to the Advocate General office, and they give a receipt letter to that effect. On 16/7/2024, they received it, and I have that receipt copy, my lord, and I have uploaded it.
What about the court? I am asking you.
Sir, I have filed it, sir, through online, sir.
Okay, it is stated that the deposition copy of the injured has already been filed online. Let the registry place the same on record. And learned counsel for the petitioner also submits that in the AG office website, the copy has already been deposition copy has already been sent. Let the learned counsel verify the same. Put up this matter next week.
also regarding the comprehensive appeal.
Acha. The learned counsel for the state drew the attention of this court that there are as many as 14 criminal antecedents.
14.
Let the land counsel for the petitioner obtain instruction in respect of such antecedent and file a comprehensive affidavit relating to the status of those cases. Yes.
Personal
Personal appearance dispensary.
Yes, ma'am.
তার নাটা দেবে
Ranjan
কয়টা?
Parmeshwar.
ঠিক আছে, ওকে। কেত নম্বর এটা হলো?
Item number 3.
My lord, on behalf of Suryakant Dwivedi, my lord, prefer 3 weeks after, my lord. In the meantime, I filed deposition, my lord. I have not received.
The learned counsel for the a mention is made on behalf of Mr. S.K. Dwivedi that certified copy of deposition of the witnesses examined in the trial court already been applied for, and some more time is necessary to obtain the same. Put up this matter, say 3 weeks kouchandi, 3 weeks pore pakai din. Yes.
Item number 4.
May I please, ma'am? Item number 4, my lord, today I am supplied ballot document.
Yeah.
Ballot document, my lord, today.
All right. Learned counsel for the
I am
petition.
submitting the matter. Verification of the address. Just found the address is wrong. They have submitted they have verified the address and have submitted the also father name they have also mentioned the wrong.
देखिए सेटा ठीक नहीं।
The last को आधार कार्ड तो अच्छी डिटेल्स address था पछोटे.
Raju Baghel, son of so and so. The verification report has been received. Same report is so and so. Onasla report.
हिंदी रे second पर अच्छी पड़ी. Mr. Tripathi.
संपूर्ण जांच में पाया कि राजू स्वानसो
जाति घासिया उर्म 29 साल ग्राम छिंदगांव डोंगरियापाड़ा थाना करपांड जिला बस्तर छत्तीसगढ़ के निवासी होने पाया गया। वर्तमान में उक्त आरोपी राजू बघेल अपने पिता का नाम वो पता बदलकर अपना नाम पता राजू बघेल पिता रामशंकर बघेल गांव मूली रोड थाना करपांड जिला बस्तर छत्तीसगढ़ बताकर थाना कंटामाल जिला बौद्ध राज्य उड़ीसा के एनडीपीएस एक्ट अपराध में जेल में निरुद्ध है। उपरोक्त आरोपी सही पता संबंध में ग्राम छिंदगांव ग्राम सरपंच पर प्रमाण पत्र एवं आरोपी के पिता का आधार कार्ड प्राप्त करके संलग्न किया गया।
बुझिले तो आपण जो एड्रेस एठी देइचंती आ जो एड्रेस पुलिस को देइचंती अरेस्ट बेले एडा सब भूल एड्रेस आपण को एड्रेस मध्ये आधेर दिया आइची क्लाइंट को कांटेक्ट करंतु करेक्ट एड्रेस आनी किनी फाइल करंतु ता परे से जो डॉक्यूमेंट बेलर डॉक्यूमेंट कथा देखिया
Yes,
हला
yes, ma'am.
the London Council for the State on Instruction produced the written instruction from Superintendent of Police Board, which reveals that the address furnished by the petitioner in the cause title is not a correct one. London Council for the petitioner seeks some time to obtain instruction from the petitioner and file the correct address. Put up this matter, give a date.
Item 5.
My lord, 2 weeks time to file the deposition copy. My lord.
The Land Council for the petitioner 3 weeks time to file the deposition copies of the witness. Arjan, next.
I
Item
got
6.
report magaitla. I'm submitting.
The Land Council for the state has submitted the what report was filed for Mr. Das?
मला अगोदर witness eyewitness हवातला केला
Who order रहेगा
मला এটা ইতলা অর্ডারটা ইতলা
police appear receive someone in respect of the aforesaid two witness ମାନେ ତାଙ୍କ ନାଁ ହଉଛି ସଲାମୀ ବୁଦ and ବାହାନାନୀ ବୁଦ ଏଇ ଦିଟା କଣ ହେଲା ସେମାନେ examine ହେଇଗଲା the Land Council for the state has produced the written report from IIC Rajgangpur police station that the witnesses Salami Bud and Bahamani Bud have appeared before the London trial court and they have given their deposition on 23/2024. The written instruction is taken on record at any. Yes, next.
Item 6.
Lordship, may please. The petitioner is in jail custody from 13/8/2020. In between is 2 times on interim bail, my lord. On last occasion, Lordship was directed to give the details criminal.
Yes, anyway,
not misutilized.
Not misutilized.
No, madam.
So last time when you were released on bail,
10/5/23, my lord.
10/5/23.
Yes, surrender on dated
In
10/8/23.
PL number
12799 copy already served. Last occasion I have given my copy.
one kete kouchendi
12799
file the copy if you
copy already last occasion I have filed.
12799 to
Yes, my lord.
acha yes 10/5/23 ଆପଣ 3 ମାସ bail ହେଇଥିଲା.
Yes, my lord. Out of these 30 number of witnesses, 14 number of witnesses already been examined, and out of this 30 numbers of witnesses, 15 number of witnesses are seizure witness.
30 ଟାରୁ 14ଟା ଏପର୍ଯ୍ୟନ୍ତ ହେଇଛନ୍ତି ଏହା କହୁଛନ୍ତି ତ
14ଟା ହେଇଛନ୍ତି ଆଉ 15ଟା ହଉଛନ୍ତି seizure witness.
and you were taken into custody on 13/8/2020.
Yes, my lord.
Are the Land Council for the petition and Council for the state submit that the petition was taken into custody on 13/8/2020 and he has been released on bail twice by this court in BLAPL number 7905 of 2021 as per order dated 9/9/2022 and in BLAPL number 12799 of 2022 as per order dated 10/5/2023, each occasion for a period of 3 months. And after availing the same, he surrendered at right time. And the present, the status of the case now is that out of 30 charge sheet witnesses, 14 witnesses have been examined and The rest, out of the rest witnesses, 15 are seizure witnesses.
sir.
Stop. As per order dated 22/7/2024, the Learned Counsel for the state has obtained written instruction from IIC Nischint Koil Police Station dated 25/7/2024, which indicates that during the interim bail period, the petitioner has not misutilized the liberty. The written report is taken on record. Considering the submission made by the Learned Counsel for the respective parties, period of retention in judicial custody, slow progress of the trial, since the petitioner has not flouted the terms and conditions of the earlier interim bail order, I'm inclined to release so for 3 months. Yes, Dex. Disposed of, yes.
My lord, period may kindly be fixed for close.
Yes, next.
Item 8.
এটা 7 वाला
ସେଟା ଦିଟା ଅଛି।
अच्छा 7 ର ଦିଟା ଆଇଟମ ଥିଲା ଓ ଦିଟା ବେଳେ ଅଛି ଆଚ୍ଛା yes
Your petitioner is in custody since 21st August 2020. 21/8/2020. Allegation under section 20B2C. Out of 15 charge sheeted witnesses, 3 witnesses have been examined.
status report আসছে
Yes, flag P, my lord, have a glance. Status report flag P. But rejection order shows 3 witnesses.
and you are a man from
Local, my lord.
Rayagada
Rayagada.
how criminal antecedent
Criminality.
ଆସିନି ମୋର
ନେଇ ଆସନ୍ତୁ ଆର ସପ୍ତାହକୁ କେସ୍ ଡାଏରୀ ପାଇନାହାନ୍ତି କି
ନାଇଁ ଦିଟା ଅଛି।
the Learned Counsel for the state submits that the matter may be taken up next week to obtain the case diary, so also the instruction about the criminal antecedent, if any, against the petitioner, put up this matter on 2nd of August 2024.
Item 9.
9, my lord, call it next week. I would soft copy to the CBI, my lord.
What copy? BLAPL?
Yeah.
Okay. So, Mr. Sarthak Naik, Learned Special Public Prosecutor for CBI, is present through virtual mode. The Learned Counsel for the petitioner submits that he will supply the copy of the bail application on Mr. Naik within 1 week. Within 1 week, put up this matter. After good week, instruction be obtained in the meantime. Yes.
Item 10.
And next week also the deposition commission they have supplied.
Deposition
Copy they have supplied. Let me verify the.
Aji dale.
supplied my lord.
Oh. 2 तारीख तल तो आसियो. The Learned Counsel for the state submits that though deposition copy of the witnesses have been supplied to him by the Learned Counsel for the petitioner, but he has not gone through the same, and the matter may be taken up next week. List this matter on 2nd of August 2024.
Item 11.
Mr. Abhishek Das. Next.
Item 12.
May I please, Lords? Your Lordship, last occasion directed to government to obtain the instruction, my lord, regarding the sufficient of notice or not.
As it appears, so Converted. Law and counsel for the state submit that matter may be taken up on so and so to verify as to whether notice has been made sufficient on the informant or not.
Solved, my lord.
Solved. Acha. Now you can argue the matter. There is no.
My lord,
What is your date of custody?
custody, my lord.
No, I have not.
You have not?
Not received a CD, my lord.
Acha. All right, take down. The Law and counsel for the state submits that when the matter was in the form of DLAPL, notice has already been served on the informant. Stop. Non appears for the informant. Stop. He further submits that the matter may be taken up next week in order to enable him to obtain the case diary. So also the criminal antecedent, if any, against the petitioner. Put up this matter on 2nd of August 2020. Yes.
Obliged.
Item 13.
May I please, my lord? I'm appearing through VC, my lord, for item number 13.
Yes.
The last occasion, your lordship directed the learned ASC to get a proof of service of someone upon the complainant.
My lord, in 13, my lord, direction was given to solve the notice, my lord. But notice has been solved in infant, but the infant is the Havilar. He is not the relation of the deceased, my lord. His mother is a witness. So notice will be solved on the mother. So my lord,
So here the Habilder,
the informant.
he is no way connected with the family.
My yes, sir.
So you should have victim. Why he made then the party that informant?
Informant is the Havilar, but he should not be the.
Ranjan Kumar Sahu. Acha, acha. Ranjan Kumar Sahu is nowhere related to the.
May I be allowed to submit my lord soon?
Mirza is the mother.
Okay, then sort the copy of the application on the victim.
Mithila Mirza.
No.
The mother of the deceased.
May I be allowed to submit one thing, my lord?
Mother of the deceased. All right. The Land and Counsel for the petition state submits that those notice has already been served on opposite party number 2. The respondent number 2, Ranjan Kumar Sahu, but he is nowhere related to the family of the deceased. He is a Havildar in town police station Sambalpur, and it is required that the notice is to be served on the mother of the deceased. And he will send a copy of the notice to the concerned police station so that IIC will serve the copy on the mother of the deceased. Put up this matter. Let it come next week and put up this matter on 2nd of August 2024. Notice be served on the mother of the deceased. In the meantime, she is at liberty to engage any counsel to oppose the prayer for bail. Matter to be listed along with CRLA number 434 of 2024. Heard so and so from the virtual High Court, Sambalpur. Yes.
Sub item to be saved.
That is it. Yes. Next.
Item 14.
May I please, your lordship? Your lordship, kind of a glance to lordship's order. Interim order passed, order dated 26/2/2024. That elaborately, my lord, it has already been discussed.
What is?
That your lordship was pleased to pass the interim bail of this present appellant.
In the earlier bail application?
In CRLA number 30 of 2024, by order dated 26/2/2024.
Where is that order?
My lord, this copy. And your lordship, in phase 3, was elaborately discussed as per the instruction of the State Council regarding the health condition.
Wait.
Phase 3. 26 into.
Yes, you are granted bail.
This present petitioner surrender, my lord, in time, and he is in custody. Thereafter, my lord.
Now what you do?
My lord, I have filed the bail application before the Lorraine court below. It was rejected. Thereafter, I have filed this application before your lordship for.
This is CRLA for.
That SC/ST Act is there, my lord, for that.
Argue on merit, no question of interim bail.
My lord, on merit, my lord, I am in custody.
Yes.
Since, my lord, 13/7/2015.
Last time, my lord, 12/7, 2004, it has came first time.
Hmm.
My lord directed to obtain the instruction regarding the health condition.
Hmm.
They prayed. The condition report is submitted, my lord. Now.
That's all right. That
But
is
CD has not received. But
get the CD.
I
The
mean,
learned counsel for
custody-
the petitioner file the copy of the earlier bail order of the petitioner, which is taken on record in CRL numbers 1.
And my lord,
State counsel submit that he is yet to receive the case diary. Matter may be taken off next week. Put up this matter on such and such date.
my lord, and in the meantime, my lord, obtain instruction regarding the status of the trial because out of 21 charge sheet witnesses, 10
Okay.
witnesses has already been examined.
Status of the trial be called for. Hala. Is it a offense under 3SC state?
Yes, my lord, and I'm in custody.
Notice sir, issue notice kar diyantu. Hala. Extra copy to be served, notice to be issued to the informant. But usual order kar diyantu. Yes.
And I'm in custody since
the 1 week
13
after. 1 week after.
1 week after. You serve an extra copy.
Yes, my lord. My lord, next week because
No, next week it is not possible. Yes, next item number 15.
Item 15.
Mr. Chan. Next 16.
Item 16.
15 there is CD as well. It will be.
Land Council for the state submit that the case diary has not yet been received. Please this matter next week. Yes.
15 there.
Lordship 16.
15 ne
15 টা মুকো
15 টা তো আমি 500
না না 15 টা মুকো সিডি আছে
ওইটা 15 আচ্ছা আচ্ছা এটা 15 রে নেক্সট উইক কর দিয়ন্তু কোন আসছি ইনস্ট্রাকশন স্ট্যাটাস রিপোর্ট the learned council learning trial court has submitted the status report which is taken on record এটা next time দেখিও হবো খালি and 16 টা কোন করে 500 বার
CD not issued.
CD not received তাহলে সেই next week কর দিয়ন্তু CD
Item 17.
17 Mr. Roy.
Petitioner is the husband, my lord. Custody since 4 years and
CD available.
CD. He has just served the deposition.
my lord,
Acha, you want
4
to
and
go
half
through it?
years in custody, my lord.
अरे आज ही परा देले तुम से deposition पढ़ी ना दी केंद्र करिए.
Omnibus.
The learned counsel for the state submitted that deposition copies of the witnesses were handed over to him by the learned counsel for the petitioner in court today, and the matter may be taken up next week. Put up this matter on 2nd August 2024.
May I file the copy of deposition?
Yes, and deposition copy for the court file taken on record. Yes.
item jo 15 বার jo
Item number 15 pura case diary asini. So next week is 2 tarik din asimo. All right. Yeah.
Published.
Item 18.
18 Mr. Lenka.
May I please, the OPID council is the upper side council.
Kore gelo Mr. Bhuiya ki Mr. Patro.
They are not receiving the phone. From morning I am trying.
Mr. Tripathi. Kaute phone kariya kuntu. Yes, next. Pass over kora.
Item 19.
May I please, your lordship? Lord, I could not file the comprehensive affidavit for the registry.
The learned counsel for the petitioner filed the comprehensive affidavit today in court, which is taken on record. Copy has also been served on the learned counsel for the state. How many criminal antecedents are there against you?
In my lord, BLFL number 3820, my lord.
Yes.
The petitioner is having 4 criminal antecedents.
Okay.
And
And 4012?
here is also, my lord, 4 criminal antecedents.
Okay. What is the offense here?
Here, my lord,
302.
302, my lord, and other allied offenses.
Earlier bail application has been rejected.
No, my lord, this is a fast bail application.
Then why it has come before me?
Well, tied up matter.
Tied up
who
matter.
accused.
Acha. So let us BLAPL 3820 2024. Here it is one petitioner.
My lord.
Horibandhu Horijan. What is the date of custody?
हरिबंधु हरिजन my lord 4/3/2024 my lord.
The status of the case may be called for. This is a case of 2019 million.
ସିଏ ପୁରା ଆରେଷ୍ଟ ହେଲେ ଏବେ 4/3/2024 ରେ ଆଉ କଣ ହେଇଥିବ ତାର absconding
Abscond my split up ହେଇକି my lord trial start ହେଇ ନାହିଁ as per my
so
instruction.
what are the materials against you?
There is no direct allegation against me my lord.
What is the name of the deceased?
This is Gupta Pujari my lord. Your lordship may kindly have a glance to the order passed by your lordship my lord in respect of the co-accused, that is at flag A my lord.
Eyewitness is Ghasiram Pujari,
My lord, who happens to be the father of the
who is
deceased
an
my lord.
injured and happens to be the father of the deceased Gupta Pujari. The three co-accused persons, Nabagowda, Jairam, and Balaram, participated in his assault. And so far as the assault on the deceased Gupta Pujari is concerned, the allegations are omnibus in nature and therefore, अच्छा, injured को 3 जन मारते injured eyewitness को.
My lord.
बाकी deceased को जो allegation अच्छी omnibus.
Omnibus in nature.
अच्छा.
FIR रे भी my lord ना नहीं यार. Subsequently, on basis of confessional statement my lord, he has been implicated.
खाली confession छड़ा और किसी नहीं.
No my lord.
Mr. Tripathi.
FIR is named.
या ना हुची.
Suri alias Surendra Harijan.
My lord, yes, 3820 टा अच्छी में. 4012 टा नहीं.
First पर इटा
3820. Sorry my lord.
इटा full application ना चल जी. This is item number 19 ना.
Yes.
19 ने कहारो ना नहीं कौचंदी.
भास्कर सागर 4012 टा नहीं 3820 टा अच्छी.
भास्कर ना नहीं FIR.
My lord.
अच्छा.
3820 टा अच्छी. हरिबंधु हरिजन.
Specific overtat की अच्छी की से जो injured
There are several eyewitnesses to the occurrence.
हाँ.
One of them is Adam Mandi.
नहीं ये जो दी जनों को रुपाई bail file ही ची.
Yes, there's Suri is the main accused.
किए?
Yes, this PT 3820.
हाँ. 30% दा
Yes, पढ़ ସନ୍ଧ୍ୟା 6ଟାରୁ 7ଟା ମୁଁ ଖବର ପାଇଲି ମୋ ମାମୁଁ ପୁଅ ଭାଇ ଗୁପ୍ତ ପୂଜାରୀ, ତୁଳସୀ ପୂଜାରୀ, ଜଗତ ପୂଜାରୀ ଏବଂ ମୋର ମାମୁଁ ଘାସିରାମ ପୂଜାରୀକୁ କଦମଗୁଡା ଓ ବରେଇଗୁଡାର ଗ୍ରାମର କିଛି ଲୋକ କେରେକା ଛକ ନିକଟରେ ସଂଘବଦ୍ଧ ଭାବରେ ଆକ୍ରମଣ କରୁଛନ୍ତି। ଖବର ପାଇ ମୁଁ ସେଠାକୁ ଗଲି। ସେଠାରେ ପହଞ୍ଚି ଦେଖିଲା ବେଳକୁ କଦମଗୁଡା ଗ୍ରାମର ସୁରେନ୍ଦ୍ର ହରିଜନ ଦିସ୍ ପିଟିସନ, ନାବ ଗୌଡ, ସୁକାନ୍ତ, ମନ, ଧନେଶ, ରବୀନ୍ଦ୍ର ବରେଇଗୁଡା ଆହୁରି ଅନେକ ଗୁଡେ ସହଯୋଗୀ ମିଶି ହାତରେ ଖଣ୍ଡା, ଛୁରୀ, ଠେଙ୍ଗା ଓ ଲୁହା ରଡ୍ ଧରି ସଂଘବଦ୍ଧ ଭାବରେ ମୋର ମାମୁଁ ଏବଂ ତାର 4 ପୁଅଙ୍କୁ ଜୀବନ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟ ରଖି ଆକ୍ରମଣ କରୁଥିଲେ। ମୁଁ ଏବଂ ମୋ ମା ଘଟଣାସ୍ଥଳରେ ପହଞ୍ଚି ଏମାନଙ୍କୁ ମରାପିଟା ନ କରିବାକୁ ଅନୁରୋଧ କଲି, କିନ୍ତୁ ସେମାନେ ମୋ ଗୁହାରି ଶୁଣିଲେ ନାହିଁ।
My lord, Adam Mandi is the informant my lord. He was the eyewitness. According to him, he has seen all the incident, my lord. But your lordship may kindly come to annexure 2, my lord, page number 14. That 161 statement of the Ghasiram Pujari, my lord.
दी जन जाक गोटे पीरियड ये थिले 4/3/2024 दी जन जाक कस्टडी गले ना अलग अलग
24 अलगा अलगा डेट अछि
तो हाड़ीबंधु गला 4324
4324 माइलर
व्हाट अबाउट भास्कर कौन सगारिया
14/3/2024 माइलर
and what are the offenses under which she has submitted?
is submitted mailor 147 148 326 307
147 148 yes
326
326
307
yes
302 and 149 21/8/19 my lord preliminary charge sheet my lord was submitted keeping the investigation open my lord
जो चारटा केस अच्छी आपण नारे सेडा की प्रकार केस
395 398
399 402 दीटा 395 केस अच्छी
my lord
से केस रो स्टेटस सब कोन
my lord NBW pending अछि reminder nei na
what is your good name
Biraja Prasad Nand
so dita common order cordon third Mr. Biraja Prasad Nanda land council appearing for the petitioners dita nahi ki ota hochi item number 19 hai na the land council for the petitioner submits that the petitioner Haribandhu Harijan is in judicial custody since 4/3/2024 and the petitioner Bhaskar Sagaria is in judicial custody since 14/3/2024 and both of them have been charge sheeted under section 147 148 326 307 302 read with section 149 of the Indian Penal Code. He submits that the name of petitioner Bhaskar Sagaria is not there in the first information report and the allegations against the petitioners are omnibus in nature so far as the assault on the deceased Gupta Pujari is concerned. He submits that one of the co-accused तादर किए बेले जाइतला से BLAPL
Ganapati Gowda
one of the co-accused, namely Ganapati Gowda, has been directed to be released on bail by this court in BLAPL number 4697 of 2019 as per order dated 11/9/2019 and therefore the bail application may be favorably considered. Stop. Learned counsel for the state submitted that the petitioners were absconders and this case is of the year 2019 and they could be apprehended only in 2014. He placed the statement of whose statement upon place kale
Adam Mandi.
Adam
Mandi.
MANDI
DI.
Adam Mandi witness eyewitness Adam Mandi. So also the post-mortem report. Considering the submission made by the Learned Counsel for the respective parties, the nature of accusation against the petitioner, nature of overtact attributed, period of detention in judicial custody, and release of the co-accused on bail, I am inclined to release the petitioner on bail subject to condition that he shall appear before the inspector in charge of Boriguda, Boipariguda police station once in a week on every Sunday in between so and so for a period of 3 months and also appear before the London trial court on each date to which the case is posted for trial. He shall not indulge in any criminal activities, violation of any terms and conditions shall entail cancellation of. Yes, allowed both the applications.
obliged
Item
18.
Is there not available? We have called for the first day.
Because they have served the copy on 20th. Today they are coming with the petition.
This for second time it was, third time it was filed on 23rd as per declaration notes. In fact, by order dated 3/5/2024, my order friend was.
No, last order is 22/7/24. And it indicates that an extra copy of the bail application be served. You have received. So bail application CD ଟା ଆଣିବାକୁ କଣ ଅସୁବିଧା ହଉଛି?
ଆଜ୍ଞା ମୁଁ ଅଲରେଡି ତାଙ୍କୁ କହିଦେଇ ସିଟ୍ ଧରିକି ଜଷ୍ଟ ଆସିକି ବାହାରେ ଛିଡା ହେଇଛନ୍ତି।
ବାହାରେ ଛିଡା ନ ପଢିଲେ କରିବେ କେମିତି?
ଜଷ୍ଟ ସାଙ୍ଗେ ସାଙ୍ଗେ ଆଣିଲେ ବାହାରେ ଛିଡା ହେଇଛନ୍ତି।
The Learned Council, Special Counsel for the state, in OPID Act meter, Master Patra submits that case diary has been received today in court and he has not gone through the same. The matter may be taken up next week. List this matter on 2nd August 2024. Yes.
Item number 20.
My lord, last occasion, Honorable Court direct to take instruction regarding interim bail, my lord. Health condition of the mother of the petitioner.
ଡାକ୍ତର କହିଥିଲେ ଅନ୍ୟ ହସ୍ପିଟାଲ କୁ ଯୋଉଠି ବଡ ଡାକ୍ତରଖାନାକୁ ନବା ପାଇଁ
My lord.
ଆଉ ଆପଣ ତ ନ ଯାଇକିନି କଣ କିଛି ଚୁପଚାପ ଘରେ ରହିଗଲେ?
My lord,
Yeah, he
କେହି
report
ନାହାନ୍ତି,
us.
my lord, ପୁଅ ଆସିଲା।
କେହି ନାହାନ୍ତି?
No, my lord.
Your IA number is 840 of 2024
my lord.
for interim bail. IA number so and so, this is an application for interim bail. बाहर करो सेटा। Number कहीं पड़ी नहीं है। On the ground of ailment of the mother of the petitioner, who is stated to be suffering from paragraph 4 disease not allergy. The Learned Council for the state was asked to verify as to obtain instruction on the interim application. Today, the Learned Council for the state has produced the written instruction from IIC Mathili Police Station dated 26/7/2024, wherein it is mentioned that the mother of the petitioner was treated at SLN MCH, Koraput for her sickness, and she is now taking medicine as prescribed by the treating medical officer. And the treating MO has advised her for better treatment at higher medical center. Considering the submission made by the Learned Council for the respective parties, the grounds taken in the interim application and the documents annexed thereto, so also the instruction obtained by the Land Council for the state, I am inclined to grant bail to the petitioner for a period of 2 months. Yes. Fix a date, he will file surrender and file the surrender certificate. IA is disposed of.
Deeply.
Item number 21.
May I please, Your Lordship? My lord, in the earlier occasion, my lord, Your Lordship had directed for address verification.
Murshidabad district in the state of West Bengal. What happened, Mr. Tripathi?
We have lately received the free copy On 24/7 we have sent the letter.
The Learning Council for the state submits that since the copy has been received lately, instruction has been sought for, but the same is yet to be received, and the matter may be adjourned to some other date, at least this matter on such and such date. Adjourn. Yes.
Item 22.
22, 23 kindly next week.
22 and 23 next week.
Item number 24.
May I please, Your Honor. My lord, last occasion, my lord was given direction to Learned AG to comply the order dated 28/24.
What order was passed on 28/6?
My lord, instruction regarding criminal antecedent and claim of parity, my lord. Here the similar putting of offence of co-accused person has been released by this honorable court in page number 47. Page number 47, my lord. The similar putting of offence, the co-accused person has been released by this honorable court. Well, petitioner is custody since 25/11/2020.
Have you gone through the order, Mr. Tripathi, which is annexed as 47, page 47? Say that the petitioner is similarly situated to that accused who has been granted bail.
No, these are totally different footing. This person.
In what way? This man who was granted bail is Pavitra Kumar Behera.
Yes, they are totally different footing. From this person, 46 kg, 390 gram gold are recovered.
No, my lord, kg not, it is the gram, my lord, milligram.
Point লেখা আছে তুমি কোন জানি?
না, সেটা সিজন লিস্টে আপনি দেখলে সেটা total ornament was 39 kilo was my lord, and the my lord, as per the mastermind who is the Ranjan Kumar Behera, was the statement of the accused, my lord. I am place it, my lord. ସଂସ୍ଥାରେ ହୋଇଥିବା
Just a minute. He is making a distinction between you and the co-accused whom you say that Pavitra Behera.
Yes.
So first try to meet it that how they are similarly situated. First of all, he was in judicial custody since 24/11/2020. You were in judicial custody?
Same date.
Same date, acha. Then
my lord, as per the statement of the Pavitra Kumar Behera, my lord was allowed the petition, my lord, reading the statement of the co-accused, my lord. S.K.Sahoo ଓ ତାହାର ଭାଇ ପ୍ରକାଶ ସାହୁ ଓ ବହୁଗ୍ରାମର ବାପି ଓର ସନ୍ତୋଷ ଭୋଇ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର, ମାଇ ଲର୍ଡ, ଏବଂ ମୁଁ ମାନେ ପବିତ୍ର କୁମାର ବେହେରା, ସେ ଦଉଛି ଷ୍ଟେଟମେଣ୍ଟ ମିଶି ଆମ ଗ୍ରାମର ରଞ୍ଜନ ବେହେରାଙ୍କ ଷଡ଼ଯନ୍ତ୍ର ନିର୍ଦ୍ଦେଶ ଅନୁସାରେ IIFL ନୟାଗଡ଼ କଟକ ସୁନାବନ୍ଧକ ଲଗାଣ ସଂସ୍ଥାରେ କାର୍ଯ୍ୟରତ ଲାଲା ଅମ୍ବିତ ସାଗର ରୟ ଷଡ଼ଯନ୍ତ୍ର ପ୍ରରୋଚନା ଓ ସହଯୋଗ ଉପସ୍ଥିତିରେ ଆମେ ଗତ 19/11/2020 ଠାରୁ ସକାଳ ପ୍ରାୟ 9:55 to 10:06 ମଧ୍ୟରେ
what you are reading is the
the charge sheet has been filed the IO.
whatever it has ପଢୁଛନ୍ତି କଣ ଏଟା accused statement
Yes,
before
madam.
police ସେଟା କଣ ପାଇଁ ପଢୁଛନ୍ତି? ହଁ
No, madam.
confessional statement of accused ପଢୁଛନ୍ତି police ପାଖରେ କଣ ଅଛି ମୁଁ ଆପଣଙ୍କୁ ପଚାରୁଛି? It's a case where charge sheet has been submitted under 395.
395
So
412
anybody has identified you in TI parade?
Yes, Miller.
So this person who has been granted bail,
Yes, my
according
lord.
to you, Pavitra has also been identified in TI.
Yes, my lord.
ସେ କଥା କହୁନାହାନ୍ତି, ସେ confessional statement କଣ ପଢୁଛନ୍ତି?
Sorry, my lord. Pavitra and also Rajkishore, page 54. He also, my lord, identified the TI.
ଆପଣଙ୍କ କେସ୍ କେତେଟା ଅଛି?
Sir, no antecedent, my lord. My lord, he is an auto driver, my lord. He is only earning member of
the Learning Council for the Petitioner and Council for the State. considering the submission made by the learned counsel for the petitioner that the petitioner Santosh Bhoi is in judicial custody since
25/11/20
25/11/20 and he has been charge sheeted under section 395, 411, 412,
No, no,
409.
no, no, my lord. 395, 412, 120B and 34.
Acha.
As per the order of the rejection of the law and court below.
Charge sheet offense टिके देखिले then charge sheet दियन आपण जो order को refer करछिन ता देरे offense गुडा के लेखा आइछि charge sheet हेछि बेल
Yes, my lord. Yes, my lord. My lord, page 16, charge sheet copy I have given.
केते
Page 16, my lord.
18 भी लिखा है रिजेक्शन ऑर्डर
हाँ,
395 412 120 B
B and 34 টা
okay 395 412 120 B by 34 of the Indian Penal Code hala
Yes, my lord.
He further submits that similarly situated co-accused namely Pavitra Kumar Behera has been directed to be released on bail by this court in BLAPL number 1683 of 2024 as per order dated 22 गरा था Now another co-accused namely S.K.Sahoo has also been released on bail
On 2/11/22.
and therefore the bail application of the petitioner may be favorably considered. The learned counsel for the petitioner has annexed the bail order copies of the co-accused persons with the bail application. The learned counsel for the state, on the other hand, opposed the prayer for bail and submitted that the petitioner, according to you, petitioner is not similarly situated. However, he submits that the petitioner, so also the co-accused persons who have been directed to be released on bail, namely Pavitra Kumar Behera and Prakash Kumar Sahoo.
Yes, madam.
All of them have been identified in the TI parent. And there is no criminal antecedent against the petitioner. Considering the submission made by the learned counsel for the respective parties, period of detention of the petitioner in judicial custody, release of the similarly situated co-accused on bail, I'm inclined to the release the petitioner on bail allowed. Yes.
Obliged, madam.
Item 25.
Yes, Mr. Panda.
My lord. Petitioner is the
Agud astile.
My lord, it is third my lord.
Third. Last time kon heitla?
Your lordship has called for the deposition copy through registry. My lord.
Kate last time mane asithile jetale kon heitla na?
Your lordship targeted my lord.
Kebe kouthre?
In BLAPL number, I have annexed my lord.
3149.
My lord.
3149 ने आपनकर सबमिशन थिला कस्टडी होची 23/2/2020 चार्ज शीट सबमिटेड petitioner is the husband earlier bail application was rejected trial has commenced 8 witnesses have been examined 4 witnesses have been declined therefore so and so state counsel submits that the witnesses examined on behalf of the prosecution have stated about the demand of dowry and torture on the deceased and the postmortem report indicate there was pressure abrasion marks present near both sides of the neck and death was due to cerebral hypoxia and burn injuries also noticed and the nature of death has been opined to be homicidal and 5 material witnesses are yet to be examined in the trial court so and so okay so kon hela apare जो ट्रायल को 6 मास सारिबा पई 20/12/2013 तापरे कोन वर्तमान पोजीशन कोन
वर्तमान पोजीशन my lord on dated my lord 22/6/2024 only 10 witnesses have been examined
status report achi
no
magaini
your lordship call for through registry the deposition copy my lord because your lordship has not called for start recently the bail application has been rejected my lord 22/6/2024 for that reason your lordship only call for the deposition copy
no 22/6/2024 लिखा है से जो
yes my lord yes my lord paragraph 12
अच्छा
page 12
हां 32 10 टा
my lord
Out of 32 witnesses, only 10 witnesses have been examined, including the informant.
Sure. Or the learned counsel for the petitioner, learned counsel for the state submits that the petitioner is in judicial custody since 23/2/2020. When he approached this court last time for bail in BLAPL number 3149 of 2023, while rejecting the bail application, this court directed the London Trial Court to expedite the trial and conclude the same within a period of 6 months from the date of receipt of the order. And the petitioner was given liberty to renew the prayer for bail if the trial is not concluded within the said period. The London Counsel for the petitioner submits that the rejection order dated 22/6/2024 would indicate that in the trial court, out of 32 witnesses, only 10 witnesses have been examined, including the informant, and therefore the order of this court passed in the earlier bail application has not been complied with. And in view of the period of detention in judicial custody, the bail application may be favorably considered. Land Counsel for the state opposed the prayer for bail and submitted that on account of demand of dowry and torture, the deceased died and the death has been opined to be homicidal. Considering the submission made by the London Counsel for the respective parties, nature and gravity of the accusation, while not inclining to release the petitioner on bail, but taking into account the period of detention in judicial custody, and since the earlier order passed by this court has not been complied with in BLAPL number so and so, inclined to release the petitioner on interim bail for 3 months, disposed of. Yes.
Obliged.
While on interim bail, he shall appear before the trial court. Yes.
Obliged.
Item number 26.
Similar. This is the second round bail application. In my earlier bail application, running page 14 Miller. Annexure Miller.
ABLAPL ko?
ABL.
Acha.
Annexure Miller 2, running page 14 Miller. And therein, my lord directed to dispose of my bail application on the submission of the London State Council as Miller 41 of CRPC complied. But in fact, Miller, in the meantime, charge sheet submitted Miller that sheet submitted 307 and other allied offences, not 41, a complied. At this juncture, may I pray, since and I also annex the statement of the injured, the injury does not Miller, and rather he Miller, the injury is caused by her husband. Therefore, Miller, I am praying first or second or parity.
The London Counsel for the petitioner
Miller,
submits.
that is the report, Miller. There is no apprehension of arrest. Police has said.
307 ରେ report
ଲେଖୁଛନ୍ତି ଯେ there is no
the
apprehension.
London Counsel for the ଏଇଟା orderଟା ଆଗରୁ ହେଇଥିଲା ସେଇଥିପାଇଁ ଆଣି produce କରୁଛନ୍ତି ଏଇଟା ନା କଣ? There is an previous order.
Yes,
Acha, the London Counsel for the state has produced the written instruction from IIC Mangalpur Police Station, which is dated 18/7/2024, wherein it is mentioned that charge sheet has been submitted against the accused persons under section 341, 294, 323, 325, 307, 506/34 of the Indian Penal Code.
Yes.
And there is no apprehension of arrest of the petitioner now. The London Counsel for the petitioner submits that the petitioner intends to surrender in the court below and move application for bail, and same may be disposed of expeditiously. Considering the submission made by the London Counsel for the respective parties, while not inclining to release the petitioner on anticipatory bail, surrender, move courts below same day expeditiously. Husband bail. It is stated that the husband of the deceased has already been released on bail, claim of parity to be taken into account. Yes.
Item 27.
Lord, may kindly pass over the matter.
CD available?
CD available, instruction is there, my lord.
Asu Simasi Asu, please.
Item 28.
28, Mr. Ramchandra Roy. अच्छा दिखे देखिए virtual mode रे ना जी okay
Item 29.
just a minute
This case
Jata, madam.
Yes, what do you say? You want to move the application?
Lordship, in this case, petitioner is in.
Just a minute. Mrs. Sahu, you have received the case diary?
My lord.
Okay, argue the matter.
Petitioner in judicial custody since.
Is it your first application?
No, this is the second bail application.
Okay. So what happened in the first one?
First one was disposed of.
In BLAPL number?
BLAPL number 2974 of 2018.
So what is the stage now?
Now, stage lordship, charge sheet has already been, final charge sheet has already been submitted, lordship, since 2019, lordship. And petitioner was earlier given interim bails 2-3 times, lordship. He has taken the interim bails, lordship. Subsequently, by virtue of lordship's order, he was directed to be surrendered, and he.
You have been granted interim bail for 3 times.
I have been granted interim bail couple of times, lordship,
Okay.
in the first bail application.
Oh, it's all right.
Yeah.
So you mean to say that you surrender at right time?
I surrendered in the last time when the case was disposed of by your lordship. Your lordship was directed me to surrender on time. I preferred a bail application before Honorable Supreme Court, and virtue of the Supreme Court order, I surrendered, lordship, on 25th April 2023.
Is there any allegation of misutilization of liberty while on interim bail?
Last occasion, lordship directed to instruction regarding the sale of the property.
I have filed an affidavit, lordship. Wife of the petitioner, she has filed an affidavit by
The
order.
petitioner willingness to sell said property, my lord, in his name. In this regard, I have already obtained the instruction and the said instruction already filed.
What she has stated in the affidavit?
He sent one letter to the Jalpaiguri, till yet not received, my lord.
So this is the letter which you are producing. It's an instruction which has been sought for.
My lord.
So that you have not received the instruction.
No, my. And as per the outstanding dues is 10 koti 96.
That is there. That is already there. See, କେତେ ଗୁଡାକ ପ୍ରପର୍ଟି ଦେଖେଇଥିଲେ ଯେ ଏଗୁଡାକ ମୁଁ ଇଏ କରି ସେଗୁଡାକ ପ୍ରପର୍ଟି ପ୍ରକୃତରେ ତାଙ୍କ ନାଁରେ ଅଛି ନା ନାହିଁ ତାର ଭ୍ୟାଲୁଏସନ ଏଗୁଡାକ ସବୁ ଆପଣଙ୍କୁ ascertain କରିବାକୁ and since it's an economic offense ସେଥିପାଇଁ କୁହାଯାଇଥିଲା.
So said EOW SP already sent on 24/7/2024.
Praying for interim bail,
and obtain that instruction whether any misutilization of liberty. He said that on number of occasions he has been granted interim bail. Have you got the total how many times you have been granted interim bail and what are the bail application number? What is the order dated? You said that number of time you have been granted bail. Huh? The registry has pointed out that you have earlier approached only once.
Lordship, in that bail application, I was able to get the interim bail only. In that original application.
Number of occasions upon कहले ना. You have used that word.
Lordship.
तो कितने थरो आपण को bail application कोटे थरो ता आछन.
I have that report from jail authority. It's showing, lordship, I got the interim bail 8 times, lordship.
8 times कौन सी BLAPL प्रथम BLAPL?
Same BLAPL, lordship.
All right. The London Council for the petitioner submitted that the petitioner was released on interim bail on some occasions and he has never misutilized the liberty. Stop. London Council for the state has produced instruction from the EOW, Superintendent of Police EOW Bhubaneswar dated 24/7/2024, which is addressed to Additional District Sub-Register Jalpaiguri for verification of the present ownership of along with the present market value and other details in respect of the properties which have been furnished by the petitioner. Wife of the petitioner, which has been filed by the no, which is based on the land which has been mentioned in the affidavit filed by the wife of the petitioner to be sold, to deposit the amount. The written instruction is taken on record. Put up this matter on such and such date. The Land and Council for the state shall not only obtain instruction as per the letter dated 24/7/2024, but also obtain instruction whether there is any allegation of misutilization of liberty by the petitioner while on interim bail. Hala, put up gote saptah pore eta hobo.
Item 32.
May I please? Charge sheet submitted under section 147, 364, 302, 201, 323, 149 IPC.
First bail application.
First bail application.
First bail application aschi mane tied up matter hisab re.
Yes, yes.
Okay, 32. It is BLAPL 13255 of 2023. So name is Lakhi, Lakhi Vidika. Your custody period is?
Custody last week of October 2023.
Last
Last week of October 2023.
October 2023. October 23. And here charge sheet submitted under section
147.
Yes.
364. 302. 201.
201.
323. 149 IPC.
What is the name of the deceased?
Deceased my Ramona Bidika.
Date of occurrence?
27/8/17.
So, is it a case based on direct evidence or circumstance?
His wife has shown the incident one day. One of the accused, that is my namely Barika Bidika, has taken her husband to a place, to a village, my lord, and the wife followed the husband. Subsequently, it is stated that some of the accused persons assaulted by means of kicks and fist blows on the suspicion that he is using witchcraft for which a person died.
No, who has seen the wife of the deceased? What is her name?
Name, my lord, Bidika Rendha.
Bidika
RENDHA.
RENDHA. DHA. Okay. The widow of deceased. Okay. She is an eyewitness to the occurrence. So she saw that some persons assaulted her husband, suspecting witchcraft. So your name finds place in that.
No, my name, my lord, subsequently came to picture that I took part in the disappearance of evidence of burning the dead body. And that moment I was also present.
So you are present and
subsequently took part
instigating, and then also caused disappearance of a
in dead body. And some persons who are took part in the assault, their bail application has been favorably considered and their bail application has been
their
allowed.
bail application has been allowed. ସେଇ ଯୋଉ ସ୍ତ୍ରୀ ଯୋଉମାନଙ୍କର ନାଁ କହିଛି
ଆଜ୍ଞା।
ବାଡେଇବା ପାଇଁ ଦେଖି ସେ ଷ୍ଟେଟମେଣ୍ଟ ଟା ଟିକେ ବାହାର କଲେ କଣ କହୁଛନ୍ତି ସେ ଯୋଉ ୱାଇଫ ତାର ଯୋଉ ଆଇ ୱିଟନେସ୍
My lord.
ସେ
1 2 3 4 5 6 8 ଲାଇନ୍ ରେ ଅଛି।
ଆଚ୍ଛା it is given by kicks and fist blows ନା
My lord.
କିଛି ସମୟ ପରେ ଲୁଙ୍ଗୁ ଗାଁରେ ପହଞ୍ଚିଲା ପରେ ସେଠାରେ ବାରିକା ବିଡିକା ଘର ସାମ୍ନାରେ ମୋର ସ୍ୱାମୀକୁ ବିଡିକା କାଞ୍ଚା ବୁରିଗା ବିଡିକା ତାର ବାପା ବାରିକା ବିଡିକାକୁ କାହିଁକି ଗୁଣି କରି ମାରିଲୁ ବୋଲି ପଚାରିଲେ।
Heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submits that the petitioner was taken into judicial custody in the last week of October 2023 and he has been charge sheeted under section 147, 364, 302, 201, 323, 149 of the Indian Penal Code. And the occurrence in question took place on 27/8/2017 and the deceased
ରମଣା ବିଡିକା
Ramana Bidika is stated to have been assaulted by number of persons and Bidika Rendha, the widow of the deceased is an eyewitness to the occurrence, who has stated that the accused persons gave kicks and fist blows to the deceased and no weapon was used for the assault on the deceased. The learned counsel submits that as per the eyewitness account, the petitioner was present at the scene of occurrence and instigating the co-accused persons to assault. And he also took part in causing disappearance of the evidence by burning the dead body. Learned counsel for the petitioner has filed some bail orders of the co-accused persons and argued that they are similarly situated like the petitioner. And therefore the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail. However, after going through the statement of the widow of the deceased, fairly submits that the allegation against the petitioner is more or less similar like the co-accused persons who have been granted bail by this court. Considering the submission nature of accusation, period of detention in judicial custody, since similarly situated co-accused persons have been enlarged on bail, I am inclined to release the petitioner on bail allowed.
Oblige.
Item 43.
Item 33 Lordship, kindly pass it over.
Pass. Case diary is it?
No, my lord. 33. In the meantime, case transferred to CID CB.
No, whatever it may be, you obtain the case diary
My
next
lord.
week.
My lord.
The learned counsel for the state submits that the case diary is not available and the matter may be taken up next week. List this matter on 2nd August 2024. Hala? CDB obtained in the meantime.
Item 44.
May I please see a case under section 20B to C of NDPS Act 1. On last occasion, this honorable court has been pleased to call for the status of the lower court.
Trial.
Ma'am. Previously, twice it was withdrawn before Honorable Justice S.K.Sahoo.
Status report indicates that so far 4 witnesses have been examined out of 14 charge sheet witnesses. That is the status report dated 3/1/2024. And your name is Jaya Golari.
He is in custody since 26/6/2020.
26/6/2020.
He is a local person.
ଗୋଟେ କିଏ ଯାଇଥିଲା ସରେଣ୍ଡର କଲାନି NBW ଇସ୍ୟୁ ହେଇଛି. Yes, Mrs. Sahoo.
My lord.
Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 26/6/2020. And in the trial court, out of 14 charge sheet witnesses, 4 witnesses have been examined. And therefore, in view of the delayed disposal of the trial, the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail mainly on the ground of seizure of commercial quantity of ganja, as well as bar under section 37 of the NDPS Act. Considering the submission made by the learned counsel for the respective parties, in view of the quantity of ganja seized and bar under section so and so, while not inclining to release the petitioner on bail, taking into account the period of detention of the petitioner for more than 4 years and slow progress of the trial, I am inclined to release him on interim bail for 3 months, disposed of. Appear before the trial court on his date. Yes.
Item 35.
May I please, Lord? Lord, the petitioner is in custody since 2/12/2023. Lord,
Kete kete?
last occasion, 2/12/2023.
2/12/23. Yes.
Lord, here he is a kiosk operator, and from the same locality, another kiosk operator was there. He was Snehasis Nanyal. He has been enlarged on anticipatory bail by this honorable court, my lord. Here, the allegations are that the 2 accused persons were the account were searched, and there are 2 transactions which are found. One from Snehasis Sanyal to Naresh Digal, and I transferred from my account to Sunil Digal. Naresh Digal has been enlarged on bail. Sunil Digal has also been enlarged on bail. Snehasis Sanyal has been enlarged on anticipatory bail, my lord. My humble submission is on the last date, if your lordship may see, your lordship had asked me to submit documents of the bailers who intend to take the petitioner on bail, and pursuant thereto, the state was directed to verify the same.
Local sureties.
My lord.
To local security document I have already sent, my lord, but till late not received, my lord.
2 तारीख रखुची.
My lord.
Learned counsel for the state submits that after receiving the names, address, and documents of 2 local sureties from the learned counsel for the petitioner, the same has been sent to the concerned police station for verification, and the matter may be taken up next week. List this matter on 2nd August
My
2024.
lord, may I only submit? In the meantime, what I have found, one of the bail documents may not to be satisfiable. My lord, I have
ସେ ତ ପଠେଇ ସାରିଲେଣି, ଆଉ ଯୋଉ ଦବା କଥା ଦେଇଦିଅ.
ଦେଇଛି
The learned counsel for the
5/5/2024 affidavit.
the learned counsel for the
ଏଇ ଦିଟା ତ ଦେଖିଲି।
petitioner served another. You will supply or already supplied?
Already supplied, ma'am.
No, my lord. Previously, Badru Dikal and Ajit Kumar Pradhan supplied.
No, 5/6/2024 I have served copy, my lord.
ଦେଖୁନାହାନ୍ତି
ମୁଁ ଆଉ ଗୋଟେ ଦେବି।
ଆମେ ଏବେ ଚେକ୍ କରୁଛୁ ପରା ଆଉ ଥରେ ରିମାଇଣ୍ଡର ପଠେଇଛି
ଏଇଟା ହଉଛି third bailer ର।
ଆଜ୍ଞା।
Another bailer ଲେଖନ୍ତୁ. He has supplied the documents of another bailer and let the same be sent to the concerned police station for verification. Hello? Yes.
शेखर मल्लिक नहीं ଟିକେ ଭେରିଫାଇ କରିଦେଲେ
Yes, Mr. Sahu.
For alleged offense, my lord.
Fast bail application.
Yes, my lord.
Uh,
Custody since
it came as a tied up matter. Is there any other accused?
yes, yes.
So one of the offenses DA 376 DA.
Notice was issued, my lord. On
What happened to the notice, Mrs.
Notice already served, my lord.
Kebe?
On 7/1/2024.
Okay. So what about the trial stage?
Trial victim has already been examined.
What she has stated? Where is the evidence copy?
Page 6.
Page 6.
Page 6, madam.
As PW 5.
Yes, ma'am.
Deposition copy ଦେଇଛନ୍ତି state council को.
Again, annex question.
Annex question. Mrs. Sahu,
My lord.
what the victim has stated? She is 13 years of age, class 7, 8. Okay. Your name is Bapun Sarkar.
Jakata Murmu.
Yan anata Bapun Sarkar to naki এটা?
No, Jakata Murmu.
Kete number কি এটা?
এটা 36.
Oh, 36.
Supported the prosecution case, my lord, on the para 1.
Co-paragraph ne?
Para 1, my first.
I along with my brother so and so, Jakarta Murmu restrained me, caught hold of my, dragged me towards nearby forest, shouted, then accused so and so, then accused raped me, fled out. Yes, Mr. Sahu.
Lordship, kindly see PW8, the doctor.
Doctor कौन कहले?
IPRC is in custody, my lord.
Oh, आगुर डायरेक्शन इतला सारी आप में?
नहीं यार, press bill application. Your lordship, kindly peruse the PW8 doctor.
Land counsel for the state. Since the victim is a minor girl and supported the prosecution case, in view of the nature and gravity of the accusation, while not inclining to release the petitioner on bail, but since the petitioner is stated to have remained in judicial custody since केबेडू
21/1/2019.
21/1/2019, and the important witnesses have been examined, the London trial court shall do well to expedite the trial and conclude the same within a period of 3 months. The petitioner is at liberty to renew the prayer for bail if the trial is not concluded within the said period. Copy of the order be communicated to the London trial court for compliance 3 months from the date of receipt of the order. Hello? Yes.
Obliged.
I'll launch for an hour. My lord wanted me to explain. I was in the right page. It was indicated as if I was reading the a act which was superseded. I was reading the right act, my lord. And that right act went out last modification has been done in 2016, I think. 16? Yeah, 16. 13 Act 2016. What I was reading, my lord, is the right act.
What is this bail application? It's an interim bail.
No, final bail application. My lord, that rejected earlier.
Item number 7. There is an IA for interim bail. IA number 565 of 24. You don't want to press this application.
My lord, because it's already, I have
Right.
already.
IA number 565 of 24. There is an application for interim bail. Learning counsel for the petitioner does not want to press this application. Accordingly, it is disposed of as not pressed. Yes. There is another. You are also appearing in BLAPL 556 of 24.
Yes.
Okay, there is also another
Husband,
bail
wife.
application not pressed. IA number 68 of 2024. So what happened? This 11483 of 23. You earlier approached this court
Yes, my
in BLAPL
4
double 2.
This is the order dated 10/7/2023.
Your earlier application BLAPL 4422 of 2020. What was passed? What order was passed?
Yes. Page 6, my lord, of that order. Considering the submissions made by the counsel for respected parties, the nature of acquisition, the huge amount collected by from innocent persons as the bedrock of false assurances, since it's an economic offense which is considered grave offense and it is committed with cool and calculated and deliberate design, which has far-reaching impact on the society, keeping in view the larger interest of the state, public and the state. I am not inclined to introduce the petition. By the time.
Then what happened?
Yes. This charge sheet is filed, my lord, in 22.
Yes, by the time this bail application was disposed of, that time also charge sheet was submitted.
Yes.
So now, what is the progress of the trial?
Trial progress is five witnesses have been examined, and none of them I'll demonstrate to my.
What is the total number of witnesses?
33.
33. Yes. So, what is your submission now?
Yes, Lord, I was indicating, my lord, on perusal of the agreement which has been exhibited. Does not satisfy, my lord. 2B, 2.
That ingredients of OPID.
Yes.
Okay. Then,
my lord, I have been now in custody for a year, my lord.
What is the date of custody of this Pallavi?
Both are, my lord, the dates are like this. Yes. Pallavi, the lady, is 5522, and the husband is 14/3/2022.
14/2.
14/3/22. Okay. Yes, any other submission?
Yes, my lord. My lord, I had taken my lords through the act.
It's all right. You have said that that agreement would not satisfy the ingredients of the offense of OPID Act, right?
Yes.
Yes. 6 of the OPID Act.
Yes, and even definition of deposit doesn't come in because it's not deposit to be money to be returned in a certain time, and interest. Not both of them are not indicated. The agreement is abundantly clear. If I may read it, my lord.
Yes.
The agreement is that I was essentially appointed as an agent of the petitioner who wanted to park his money for the purpose of investment.
Yeah.
I'll take my lords to the agreement which starts, my lord. He has given one of them as 5 lakh, my lord. The amounts are not very relevant, and they are all people, my lord, of consequence. 25 lakhs, 5 lakhs. They are not. It's not a Ponzi firm, nor are they small people, my lord. They wanted to park their money for the purpose when they didn't have the expertise, so they came to us. My lord, kindly, I'll read that. The first party is authorized and to represent the managing of the funds. Invest, reinvest, maintain in cash or cash equivalent, acquire, dispose, and otherwise manage any part. I was to manage. Essentially, my lord, I'm an agent. Purely civil contract, my lord, in the realm of contract. I have a right also, my lord, to select the place, orders with dealers, brokers to purchase and sell or otherwise trade and deal in securities, and negotiate applicable terms, commissions and charges for the schedule from the brokers. That means essentially, my lord, either it's going to be in bond or share or things like that, my lord. Perform all other acts that may be in the judgment necessary, appropriate for management of the funds on its obligations under the agreement. The first party, all information provided by the second part as confidential. I am bound by confidentiality also, so that they don't know how much of money he has invested on with me. It's a fiduciary relationship, and I put it in various routes of financial either share or things, and then over a period of time, 6 months period is given. 6 months period, they take back the money, and it's a continuous process. Supposing there's a loss one time, that also is sheeted. And that loss is supposed to be adjusted in the later period of time. It was first time, it was honky-dory, money was coming. Then it went to bad time, my lord. When it went to bad time, my lord, they are supposed to be indemnifying me. Rather than the opposite, my lord, may kindly see, the second party will hold, that's clause number 6, the second party will hold harmless and indemnify the first part, its directors, officers, and employees against any or all claims and losses, damages, and liabilities and expenses which the first party may incur, and the extent that such a loss is caused by the second part or the second party, that designee's own action. It was, my lord, it was deemed to be their action, my lord. When I was essentially the agent. By any inaccuracy or breach of the client representative and warranties, my lord, it was deemed to be, my lord, I was essentially like a agent, my lord, just like an agent under the Contract Act, my lord. Then, my lord, B of 8. The second part, second part has, my lord, second part may or may not invest with me, not as if he has to invest with me. The second part has a legal power to enter into agreement without notice or consent with any party. So they directly can deal also.
Like, my lord, shareholding, anything they want to go directly, they can
Mr.
go.
Das, I am not supposed to go detail into these things because if I give any finding, that will have some kind of.
I quite agree, my lord. I bow down to that, my lord.
Yes.
I'm only saying prima facie does it make out case. That is, I'm ending there, my lord.
Yes.
I'm only saying this much, that then, my lord, the second part is an individual, my lord. The
Yes.
second part is not a party bound or affected and subject to any indenture, bond, mortgage, or anything, my lord. Which, my lord, in anything else he does, my lord, he has to. If there is a mortgage, my lord, he has to mortgage. I essentially only deal with his money when it's available to me for the purpose of investment, my lord.
Hmm.
And there is, and my lord, the agreement also says it cannot be assigned to anybody. It is interested, just like agreement of agency.
Yes.
That either party can terminate the agreement with 30 days notice. And if any time subsequent to the date whereof any provision of this agreement is held by any court or competent court of jurisdiction illegal, void, or unenforceable, such provision shall have no force and effect, but the illegality or enforceability of such a provision will have no effect upon or impair the enforceability of any of the provisions of the agreement. They also say, my lord, they say, but essentially, my lord, giving money to me and saying that you'll be also duty bound by the agreement, even if it is illegal, because you have taken money for the purpose of investment. That means I was basically a person who was a custodian of his money. This is the agreement, my lord. This has been one of the witnesses. This is an exhibit also, my lord. Now, and they admit that they knew him very well. They admit that he had the expertise. His background, my lord, is that he was in the merchant navy. He was a captain in the merchant navy. He left his job. Mathematics background, he thought that he will do this business and not be sailing too long. And that is how he came, my lord.
Yes.
Even, my lord, financially, if I'll just take, my lord, to 3-4 things. B, which has defined, my lord, depositor, receipt of money or acceptance of liability to be returned in a specific time. That's the second part of that section. Either in cash or otherwise, in form of specified service, with or without interest. There is nothing here about interest, my lord. Whatever the interest comes from their investment, it will go to them.
Yes.
D, my lord, is financial establishment. Receiving, my lord, very clearly, receiving deposits under any scheme or arrangement or any other manner, but does not include corporation or corporate bank owned or controlled by the state government. There has to be a deposit, my lord, for the purposes of I assuring him return. I don't assure him return. I am only an agent of his, my lord. Then, my lord, regarding the law on the subject, my lord, it has been most succinctly put by my lord in Gajanan Properties.
Yes.
Gajanan Properties, that dealer of that land and things like that, my lord. My lord held that where you have given money for the purpose of getting something, you didn't get it. At the highest level, it's a civil contract. And where is the question of a mens rea or the purposes of it? And where is the mens rea in the first instance? Right, my lord, that is that 2018 2 OLR. And I had given, my lord, in the another case that I was arguing before, my lord, that this judgment has been upheld by the Supreme Court. I'm giving, my lord, a copy. My learned friend would be aware of it very much. My lord, the ingredients, my lord, as in the first instance in the head, no, returning the deposit of any financial instrument, default in payment of interest of financial establishment, failure to render the service of a financial instrument, which the deposit was made. All through, my lord, it is very indicative. My lord, this basically, my lord, was to avoid the Punji money to go away. And the state enacted this in 2013, my lord. I have got the legislative debate also. That is clearly that people are coming and taking away money from the people. And that is the reason why the objects are not very elaborate. If my lord may kindly read the object of the act is not very elaborate. It only says, an act to protect deposits made by the public in financial establishments. That means I have to be a financial establishment and it has to be a deposit of the public. Relating to matters there, to my lord, then the elaboration. I am only showing prima facie, my lord. It fell from, my lord, a question was asked by my lord that why didn't you file an application to discharge? My lord, I cannot improve the case now, my lord, unfortunately. I can only beseech my lord to accept the fact that if I make prima facie a case, my lord, that it doesn't fall within the year, that my lords have decided that my lords can consider. Then Gajanan property, the paragraphs, my lord has dealt with a few of the most important judgments in the and then my lord have held that OPID Act doesn't apply to these things, these cases. These were that HAL land, my lord. So, my lord, therefore, my lord, I say prima facie OPID Act doesn't apply. All others are minimal offences, my lord. Even if it is, I mean, I'm entitled to bail on those matters. My lord, what comes between his incarceration continuing or being discharged is the OPID. It fell from my lord that what is the change circumstances, my lord, between that day and now. My lord, I don't want to. My lord, this was not argued in this perspective at all. It was almost an acceptance about the fact that prima facie case is made out. One, my lord, and the incarceration for so long, my lord, and no custodial interrogation necessary. All documents being all papers being documentary, and I cannot in any way tanker or tinker with the evidence. In that view of the matter, my lord, I was beseeching my lord to exercise the power in the second time, my lord, on request of the petitioner, my lord. Yes. My lord asked me a question that regarding the that you cannot. I mean, you are this is a economic offence, and strict rules will apply. My lord, for that, my lord, I just want to. I mean, my lord is aware of it. Until judgment in paragraph 66, my lord. I'll give my lord that. I'll give my lord the reference, my lord. I think my lord, I had to place it before my lord earlier. Until is 2022, SCC online 825, my lord, I'll give that judgment. I'll place, my lord, paragraph 66. My lord, they discussed that. They discussed one thing, my lord, as to they tested it basically in the Article 21, my lord. And they gave, here, my lord, very eminent senior counsel were assisting the court, and they decided to lay down the parameters, and they indicated it will be factual in all aspects, but the general parameter they gave. So, paragraph 66, they say, what we are left with now is to discuss our economic offences The question for consideration is whether it should be treated as a class on its own or otherwise. This issue has already been dealt with by this court in the case of P. Chidambaram, Enforcement Directorate so 2013 SSC so and so. Taking note of the earlier decisions in the field, the gravity of the offence, the object of the special act, and attending circumstances are few of the factors which have been taken into consideration, and the period of sentence. After all economic offences cannot be classified as such. It may involve various activities and may differ from one case to another. Therefore, it is not advisable on the part of the court to categorize all these offences to one ground and deny bail on that basis. Suffice to say that the state has laid down the following, to state that law has laid down. Chidambaram is quoted there, my lord. And it says that bail is rule, rejection is exception. Then, my lord, they again, my lord, Chidambaram got out, my lord, in 1 month something. Sanjay Chandra is that 2G matter. They were all granted bail within 6 months. 3 to 6 months. Far more ramification, far more public money involved. Direct public money. My lord, that is the distinction that these judgments made, saying that regarding the deposit, my lord, which my lords directed that deposit. They said if it is public money, that means state money. There, my lord, the tests are different. You can, the Honorable Court can bind them with a deposit because it is essentially recovering the government money, my lord. But in private contract, if there is a default or otherwise, it cannot be, the court should loathe to give a deposit matter. Sanjay Chandra, again, my lord, 3 to 6 months, all of them have been enlarged on bail. And my lord, may kindly take after that Potter case of Lalu Yadav, where he was convicted. Potter case, my lord, he was enlarged on bail in 6 months. Both the former chief ministers of Bihar. That, my lord, is, I'm giving that also. This is which page is it? 60. When it starts. The most serious of the offences now pitted against the petitioner is 13 of Prevention Corruption Act, maximum imprisonment 7 years, having considered the merits of the case. But my lord, it is not so much the 7 years. It was in hundreds of thousands of crores, my lord, where he has been convicted now. Then I'll take my lords to this judgment of Subhash Chandra, which my lord is that 2012 judgment in 4G. They said, Justice Dattu, as he then was, my lord, Chief Justice Dattu, he said, we are conscious of the fact, paragraph 46, my lord, we are conscious of the fact that the accused are charged with economic offences of huge magnitude. We are also conscious about the fact that the offence allegedly proved may jeopardize the economy of the country. At the same time, we cannot lose sight of the sight that investigative agencies already completed investigation. And the charge sheet has already been filed by the before the Special Judge CBI. Therefore, their presence in view, presence in the custody may not be necessary for further investigation. To grant bail, trial on the stringent condition, in order to allay the apprehension expressed by CBI. CBI said they might run away. There, my lord, one Oriya IAS officer also was involved. So all of them got acquitted, man, ultimately. But this is what, my lord, they said, and they within 3 months they granted them bail, having considered there's a huge magnitude and it might affect the economy of the country also. Here, my lord, they say at the maximum it's 5 odd crores, my lord, and it is all individuals. It is no public money that is involved, my lord. My lord, that the judgment I had given, my lord, that Kamlesh, yesterday, day before yesterday, a bench also, that very, the presiding judge was a judge who was speaking for the court. Paragraph 5, my lord. It's repetition, but my lord, only for the purpose of showing that this is the latest judgment of paragraph 5. Yeah. And my lord, also in those judgments regarding that, the judgments of in the matters regarding the Monoporum and IFFL, my lord has granted bail to all of them, the largest of large people. My lord, who really, that is really public, I mean, absolute, one of them, very serious offense, my lord. All others had been granted bail, and that was the basis of the bail, my lord, which was granted by the Supreme Court. My lord followed those judgments, and I was doing that matter in the Supreme Court, my lord. And my lord, I had given my lords that those matters when I argued the subsequent matter also. One matter I argued after that. That is all. I leave it to your lordship's wisdom. Yes, Mr. Bhuiyan.
Lord, at the outset, I will move the submission of my own opinion on the basis of the decision placed by my own senior, that is 2013 7 SCC 461. Ramesh Kumar. Lord, your lordship, kindly have a glance. Only Ramesh Kumar, that is an individual 420K. None of the economic offences or other sections are involved, like that of this case. Lord, your lordship, kindly keep in mind. In the present case, he has been charged with commission of offences. Lordship, Lordship has considered it in the previous application while granting and refusing bail. He has been charged with 420, 406, 467, 468, 471, 120B, read with 456 of Price Checks and Money Circulation Banning Act and Section 6 of OPA. Out of these, below, at least in 3 of the sections, those are non-bailable in character, and the punishment is much more than 10 years. Whereas the Ramesh Kumar case, he had only implicated in 420 in the allegation of one of the individuals. Here, there are many people to whom he has cheated. So the consideration in Ramesh Kumar case and the present case stood in different positions here. So Lordship, kindly keep see para 26 of Ramesh Kumar case. There the Honorable Court itself reserve his findings over the economic offences are concerned, my lord. I may place it. We may, however, not.
You are placing paragraph?
Paragraph 26 of Ramesh Kumar case, that is 2023, volume 7, SCC 461.
Yes.
This is the opinion. We may, however, not to be understood
to have laid down the law that in no case should willingness to make payment deposit by the accused be considered before grant of an order for bail. In exceptional cases, such as where an allegation of misappropriation of public money by the accused is leveled, and the accused, while seeking indulgence of court to have his liberty secured, restored, volunteers to account for whole or any part of the public money allegedly misappropriated by him, it would be open to the court concerned to consider whether, in the larger public interest, the money misappropriated should be allowed to be deposited before the application for anticipated bail or bail is taken up for final consideration. After all, no court should be averse to putting the public money back in the system if the situation is conducive therefor. We are minded to think that this approach would be in the larger interest of the community. However, such an approach would not be warranted in cases of private dispute, where private parties complain of their money being involved in offenses of cheating. Turning to the fact here, what we find is that the version in the FIR, even if taken on face value, disclosed payment through check of rupees 17 lakhs in the name of appellant and not rupees 22 lakhs. We have not been able to comprehend how the High Court arrived at the latter figure as payable by the appellant and why the appellant's counsel as well agreed with such figure. Privacy, there appears to be some sort of calculation error. Also, privacy, there remains some doubt as regards the conduct of the appellant in receiving the check from the complainants without there being any agreement intersect. Be that as it may, the High Court ought to have realized that having regard to the nature of dispute between the parties, which is predominantly civil in nature, the process of criminal law cannot be placed into service for settlement of civil dispute. Even if the appellant had undertaken to make payment, which we are inclined to believe was a last-ditch effort to avert losing his liberty, such undertaking could not have weighed in the mind of the High Court to decide the question of grant of participatory bail. The test for grant of participatory bail are well delineated and stand recognized by passage of time. The High Court I am not here.
Yes.
Your Lordship has exactly held as my senior has placed in the case of Gajani. Your Lordship may kindly see that Gajana was challenging an appeal, my lord, under section 13, challenging the rejection of application to discharge. Here, your Lordship is only considering an application for bail. And therefore, the question what ought your Lordship's mind in granting or considering the Gajana case has got no application here, my lord, because that is in due discharge of section 239 application. Here we are only on the application for grant or refusal of the bail. Now your Lordship has already taken a decision which has holding the field, my lord. There is no change in the situation. That decision neither my Lord Senior has tested it, nor he has said that that decision requires a reconsideration. This is not an application, my lord. A fresh application was put before the Lord High Court again for bail. That being rejected, now the present bail application is being considered by your Lordship, my lord. Now, your Lordship, after considering the materials available on record, your Lordships have previously granted me with a condition to deposit, my lord, that he has not honored. Your Lordship has recorded it in the previous order.
That final order I have mentioned.
Yes, your Lordship has recorded it. Now, my lord, so my learned senior is now wanted to subterfuge the decision taken by your Lordship in a manner approaching this court again and again. My lord, such a approach is not to be encouraged. My submission before your Lordships, though there is no res judicata in criminal, my lord, to the very approach may not be encouraged, my lord. And your lordship, so far, the decision of the apex court in concerning economic offences, your lordship has considered in many cases, the cases of Nimagada Prasad, the cases of Jagamohan Reddy, your lordship has already decided many bail application on that basis, because admittedly the accused has taken more than 5 crores of rupees from many persons. That is the very object of the OPID Act. By your lordship, this act was enacted keeping in view by merely punishing a person, the person those have been cheated, they will not be get anything, because they will not get the money which they have invested back. Keeping that, if that was the legislative intent to bringing in the act in question, my submission before your lordship, we have during the course of investigation, we have not found even that I proves. Though the act, the very object of the act is to secure the repayment of the investment. Here, the person in concern has not only cheated the public money, he also wanted that he should be grant bail so that he can commit the similar offences, because his presence in the society is a threat to the society.
No, what has been come in the meantime, as I was going through the evidence also, the 33 witnesses you are proposing to give, out of which you have examined already 5 witnesses. Now, if we see the evidence of these witnesses, let us come to one of the witness, PW2.
It is their witness, and he is a prosecutor. It's very sad that he's asking this question.
PW2, अच्छा आपन पर अच्छी जदी टिके देले कॉपी टे PW2
I should be asking the prosecutor, my lord.
PW2 PW2 को आसंतु एई टाइप रो सब प्राय कहिसंती come to one PW because the amount is little higher, so that's why I'm coming to that PW. You come to paragraph number 10. You see what he has stated, that except 44 lakhs 90,000. Did you get it that? Only against my investment of 89 lakhs so and so, the accused Satyaranjan Hutta and his company did not pay the rest amount. So,
the FIR story is that that he has for return of the money, he has even supplied many checks to the persons, and most of the checks were dishonored. That is admitted in the FIR.
No, similarly has been stated by other witnesses who have verified, but the amount is little less, or that is why I'm come to that. So, how many more depositors are there to be examined?
What I have gone to the
Out of 33, some may be also the seizure witness, one or two may be the investigating officers, like that. So it is not that all the rest would be the so. And one of the argument what he is advancing, suppose they have remained in custody for 2 years, right? Now the evidence has already, recording of evidence has started, and the purpose of the bail is to ensure the attendance of the person in court and to see that there is no chance of tampering or absconding. That is one of the main features. So here, if the persons are local man and there is no chance of absconding, and since it's a case based on mainly documentary evidence which are already you have seized and is in the custody of court and is likely to be exhibited during trial, and if this type of evidence is to be adduced by the rest of the witnesses, let us say, because let us say the other witnesses would turn hostile, but if
let us 3 to 4 witnesses which have already been examined give this evidence. Now the question would be that whether this offense under OPID Act, because that is the main offense, is made out or not. So at this stage, if these two are released on bail, what you are likely face difficulty during the trial?
So Lordship, may kind see that witness of that PW2 again.
Yeah.
He has proved certain documents.
Yeah.
So Lordship, may kindly visualize that all other witnesses, many of the witnesses, are to call to the doc to prove certain documents.
No, these documents you just see that.
That is exhibit P to 511.
We are coming to PW2.
Miller, your Lordship, may kindly see PW2. He has proved.
Now, obviously, he is to whatever documents has been issued in his favor, he has to prove, and that is how he has proved also these documents in paragraph number 9, right?
Now,
So,
kindly pause here.
yeah.
Suppose similar witnesses after his release is either threatened because of his presence outside, or they have been gained over. So the very release will cause an obstruction for the fair trial. He is a person who has taken money. So the grant of receipt to them has been seized. So unless those things are established through those witnesses, then certainly the offense cannot be proved.
No. Suppose you have already proved 5 cases, 5 depositors. So now the number will be increased. So suppose those numbers are reduced. If the 5 are proved, can you say that if this is believed and you say satisfy the court, that is the ingredients of the offenses are made out merely because the other witnesses are turned hostile, then the court will not convict the person? It is like that. Suppose in a case where 5 eyewitnesses are there, 2 have supported the case and 3 have turned hostile. That doesn't mean that court cannot rely on the 2 witnesses and.
That is so far. I am not so far the criminal case is concerned.
It's a civil case.
It is a criminal case, but it is a quasi civil in nature because it depends upon the documents. And your Lordship, kindly visualize in economic offences. There are 3-4 types of document is required to be. One is that in fact whether he is a financial institution, whether he has allured the public, whether he has received money from public, whether he has granted receipt. These are things, my lord, is required to be established through prosecution. So 5 witnesses might have proved some type of document, my lord. The other type of document is required to be proved through certain other witnesses.
So, you see, you are advancing an hypothetical one. Then what are those? It would be the similar documents, Mr. Depositors ସମସ୍ତ depositors को गोटे प्रकार ये ହେଇଥିବ ଏବଂ ସେମାନେ ଆଉ ଇଏ କଣ ଆଉ ଗୋଟେ ପ୍ରକାର କଣ ତାଙ୍କୁ କଣ ଯଦି ଆଜି କହୁନାହାନ୍ତି କୋଉ ଟାଇପ ର
depositor କୁ ଆମେ investment ରସିଦ ତାଙ୍କ ଦ୍ୱାରା ସିନା investment ରସିଦ prove କରିବୁ ଅନ୍ୟମାନଙ୍କୁ ସାଇଡ କରିଥିବୁ।
No, I am putting you this question. Please satisfy me. If they are released on bail, because I have to see also that is whether absconding is there, whether likelihood of tampering is there, so that the trial is likely to be so affected in that way. So, if anything comes out against the persons who are to be misutilizing, and in spite of putting the condition, then you are also at liberty to file application for cancellation of bail.
Considering it, you not granted bail,
that
the amount will be secure, so that he cannot escape his liability from the court. Either he may not appear, or he may not put certain hindrances in trial. That was your lordship's intention to grant him in bail. It is not that he has been refused.
No, in some cases, economic offences, the Honorable Supreme Court, this court also directed to deposit the amount not even one time, but installment wise, like in Sahara case, other cases are there. But in some cases, the observation comes that no, the court should not be a recovery agent like this. So that is the view. So
kindly see your lordship's order. Your lordships consider that he has taken 5 crores 24 lakhs 36,700.
yes,
And against that, your lordship only imposed to deposit 15 lakhs. That is only for the purpose of
no,
securing his
the
presence.
why that was said that she said that if in case I am released on interim bail for some time, I may arrange the see that arrange some money. So for the purpose of interim bail, that amount, that was the argument advanced during that. Otherwise, I would not have asked against 5 lakhs to deposit 15 lakhs to go on bail.
I'm not
Because
saying the quantum.
yeah.
My submission, your lordship, keeping in view that his presence can be secured. Your lordship imposed that amount. Now he has failed to pay it, Miller. Now he is trying to take advantage of his own wrong. Your lordship impose that amount so that he can abide by your lordship's order as well as the order of the Honorable Trial Court, and the trial can be expedited. But still, then he failed Miller. Now he is before your lordship that I cannot deposit. So he is trying to have the cake and eat it. That is my submission.
Okay, but when did you frame the charge? Let us know it. When the charge was framed?
Then
Charge. Why are you not keeping your IO with you when you are arguing a matter like this, OPID matter? These are all mostly economic offenses are involved. So yes, that's it is to help you immediately. They can say no charge sheet submit hela mane noy je charge frame heyi because the city case number is 4 of 2022, right? So the charge may have been framed. The FIR was in 2022. Okay, so charge the first witness as it appears, it was examined in 12th April 2023. Okay, and if feet of 5 witnesses have been examined, the last witness was examined on 26th February 2024. We also asked you on the other day, I asked you to take instruction as to whether any.
I have informed the IO he is not there. That is why.
No, I asked you that whether any further witness has been examined. Mr. Das said that he had instruction, no further witness. No further. So it is 5. So just see PW1 examined on 12th April 2023.
23.
Okay. So now PW5 was examined on
January.
No, it is February 26 to 2024. So let us say that the trial commenced or the charge was framed in January 2023. We do not know exactly when. It might have been framed earlier also. Karan examine heichi PW1 12/1/2023. So 1 year and 7 months have already passed, right? Or at least 1 year 6 months. 6 months have already passed, and you have only examined 5 witnesses. Huh? So if total number of witnesses is 33, and in this process, if you will go, then it will take another 6 years.
Make a target.
No, target apano.
You can also pass a direction to expedite the hearing and conclude it within a particular period.
No, that's all right. But what you are doing from February to July? Why not a single witness was not?
I was handicapped. So he has gone for investigation.
No, many things are to be seen while considering an application for bail. A delayed trial is also one of the ground, right? So the conduct of the prosecution, if this, you are deliberately within a span of 1 year and 6 months, if you are only examining 5 witnesses, it is not that the witnesses examination is going on days together. So they are just to prove some documents and to be cross-examined and discharged on the same day, as it appears to have also happened in these cases. So in that case, the negligence of the prosecution is there. That means they are not producing the witnesses. The one lady is there out of these two. One is lady, and they are no residents of Denkanal, madam. No, I said that local. I verified it that they are local persons. And for ladies, as you know, 437(1) proviso is a special consideration also for them. Anything further you want to say? Have you got the copy of the charge sheet with you? We have got the copy of the charge sheet. We can give it to my lord. Please pass on so that I am reserving the order. This extra copy. We have annexed it, no?
No, sir, this not has it. It hasn't been annexed.
556?
No, it hasn't been. It was just
If my learned friend can't give, I can give the. Just give the charge sheet copy because FIR you have annexed,
Yes,
and no, nothing more is required. Only the charge sheet. That witness list is there, na, in that.
yes.
All right. And just mark those 5 witnesses who have been examined and mention that this is PW1, this is PW2 from out of the 33, because the deposition copies is that is with them. So just by the side, you can just note it. This is PW1 to 5.
Witness listed second ଅଛି PW1.
Just verify and file it. Just give it. Say charge sheet copy টা ରଖିବେ ହଁ ହେଲା and keep this list ଏଟାକୁ stapling କରିକି ରଖ. So that's all, Mr.
Yes,
Dasu.
No, I just want to, as an officer of the court, I owe it to myself, my lord. But almost an allegation was made against me as if I misled the court by submitting something which is wrong in paragraph 26. My lord,
Paragraph
26 of the Ramesh's judgment. I didn't do that, my lord. What I stated was, if it is public money, supposing it's a Tahsildar who's granted bail, and it is specifically indicated, my lord, it is not things that are every money is not public money.
Only public money they have not stated.
Yes,
they
my
have,
lord,
they
public
have,
money.
They have stated public money and he must offer voluntarily.
Yes, my lord.
Then can only the court impose condition
Yes,
authorized.
yes. No, public money is also there, my lord. I'm only saying.
No. Public money ହେଇଥିଲେ ମଧ୍ୟ court ମାନେ bail condition put up କରିପାରିବ ନାହିଁ ଯେ ଏତିକି deposit କଲେ public money ହେଇଥିବ ଏବଂ ସେ volunteer କରିବ. Please come to that para once again.
Yes, ma'am.
Just see that.
We may, however, not be understood to have laid down the law that no case of willingness should be payment of deposit. Yes, what is falling from my lord is absolutely right. And my lord, here we are minded to think that the approach would be larger interest to the community. However, such an approach would be warranted in cases will not be warranted in case of private disputes where private parties complain of their money being involved in the offense of cheating.
The next line is important.
Yes.
In exceptional cases.
Yes.
Such as where an allegation of misappropriation of public money by the accused is leveled.
Yes.
And the accused, while seeking indulgence of the court to have his liberty secured, volunteers to account for the whole. So that is the.
No,
that means.
I was understood as if I am stating.
No. That's So please give that charge sheet copy to me and mark those 5 witnesses and deeply obliged, my lord.
My lord, I am appearing through VC, my lord. My presence may be noted, my lord. I am to the informant, my lord.
Anything you want to say, Mr. Counsel?
My lord, that whatever submission has been made on behalf of the counsel appearing for OPID, my lord, I was also harping on that paragraph 26, my lord, what he has already submitted, my lord.
Now, China say list, cause list.
My lord, J. Sahoo and S. Mahapatra, both the names are there.
Okay. So, Land Council, I'm reserving the order in both these bail applications.
My lord, my lord.
11483 of 23 and 556.
And 556, my lord.
Okay, all right.
My lord.
Now you all those matters which were mentioned in the first hour, then we'll go serially. If you would have you 100 ପରେ ଯୋଉ କହିନଥିଲି ସେଗୁଡାକ ତାଙ୍କୁ କହିଥିଲ ଫାଇଲ ଆଣିବା ପାଇଁ କି ପ୍ରୋବ୍ଲେମ
Item number 100.
May it please your lordship. My lords, I am appearing in VC. I may be kindly permitted to submit through VC, my lord.
Yes, sir.
I am obliged, my lords. The item number 100, my lord, the petitioner is in custody since 2012-2019. And my lord, the charge sheet has been filed on 9/4/2020.
What are the offenses?
Offenses 420, 465, 467, 468, 471, 120B, 34 IPC. And my lord, the allegation is the petitioner has received 17,50,000 in his bank account for giving a seat in MBBS course, my lords. Along with the petitioner, there were two co-accused, prime accused Dr. Raghunath Behra and another person, Subhasis Pati. Your lordship, my lords, the Raghunath Behra has admitted the entire liability, and it is there in the charge sheet also that he has given a check of 18 lakhs, which of course, obviously, my lords, it subsequently got dishonored, and he has also been released on bail by this honorable court, wide BLA PL number 437 of 2021.
2020 लिखा है जी 2020 लिखा है जी 437 of 2020.
Confusion was there, my lord. Lordship has verified.
It is 21. It is 21.
Yes, my lord. Yes, my lord.
Okay.
And it directed me to file a comprehensive affidavit because, my lord, similar nature there were cases in which I have filed the affidavit, where in all the cases he has been released on bail. The present petitioner, he has been released on bail. This is the only case pending, my lords. And my lords, there are 5 cases as per the charge sheet pending cases in Bangalore. My lords, we have no instruction with regard to that Bangalore cases, and also I verified from the one of our learned friend from Bangalore, my lords. We could not find anything of that sort. But my lord, that also I have mentioned in my affidavit. And lordship has directed the learned trial court to furnish regarding the deposit of the amount which
Yes,
has.
Mr. Tripathi.
Yes, Miller.
The order which was passed on 28/6/2024, I called for the status report.
Yes, Miller.
And the status report indicates that out of 11 charge sheet witnesses, 1 witness has been examined. And it's here the misappropriation amount or whatever it may be, cheating amount, that is 17 lakhs, he says.
17 lakhs 50,000.
17 lakh 50,000. Okay.
Yes.
And this man is in custody for 4.5 years, he says. 2012-2019.
Yes.
Are the learned counsel for the petitioner, learned counsel for the state?
And all the amounts has gone to his account, this petitioner's account.
No, there was a condition put to that Raghunath Behera that he has to deposit the amount. So, are the learned counsel for the petitioner and counsel for the state. This date is correct, na? 20/12/2019.
Yes.
The learned counsel for the petitioner submit that the petitioner is in judicial custody since 2012-2019, and he has been charge sheeted under section 420, 465, 467, 468, 471, 120B of the Indian Penal Code. As per the order dated 28/6/2024, the London Trial Court has submitted the status report, wherein it appears that out of 11 charge sheet witnesses, only one witness has been examined. Land Council, Land Council submit that the cheating amount is 17.5 lakhs, 17,50,000, and similarly situated co-accused, namely Raghunath Behera, has been directed to be released on bail by this court in BLAPL number 437 of 2021 as per order dated 10/8/2021. The where is your comprehensive affidavit?
My lord, it was filed on 16/7/2024.
Is it available on it? It is not there.
My lord, sir.
Noting is no such affidavit is there.
My lord, in course of the day, I'll file another copy, my lord.
Send it. What
Yes,
have you received the copy of the comprehensive affidavit, Mr. State Counsel, Mr. Tripathi?
Yes, my lord.
Is it there with you?
Yes, my lord.
So, how many criminal antecedents are there?
My lord, sir. 8 in
12.
What type of cases are there?
All similar, same.
Achha. The learned counsel for the petitioner has filed a comprehensive affidavit to the criminal antecedents against the petitioner. Considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody, the slow progress of the trial, and since one of the co-accused has already been released on bail, I am inclined to release the petitioner of any comprehensive affidavit of recognition. I am inclined to release the petitioner on bail subject to condition that he shall appear before the London trial court on each date when the case would be posted for trial, and shall not try to come in contact with the prosecution witnesses or tamper with the evidence, and shall not indulge in any criminal activities, violation of any terms and conditions shall entail cancellation of bail allowed. Next.
Item number 104.
Yes.
It is a custody from 23rd.
Please use the mic properly. Yes.
Custody from the 23rd July 18, my lord. In the meantime, twice he has released an interim bail. Last occasion, lordship died for the status report. And similarly situated co-accused person has released on bail.
Status report indicates that out of 27 charge sheet witnesses, 9 witnesses have been examined.
Yes, my lord.
It's a case under section 302.
Yes, my lord.
Okay. Last time when you have been released on bail?
I have
interim bail.
Yes, on a 522 bail number 522 of
22.
22.
As per order dated 13/5/2022.
Yes, 13/5.
Okay, 3 months you have been released. Okay.
Yes, my lord.
So, anything adverse reported against the petitioner?
Well, that is not common. No instruction is sought for.
Okay. Mr. Counsel, Mr. Tripathi.
Yes, ma'am.
The very first order, order number 1, in which I have stated, let the London Council for the State produce the case diary, instruction about the criminal antecedent, if any, against the petitioner. So also instruction as to whether there is any allegation of misutilization of liberty by the petitioner while he was on interim bail or not. The order to pass ହେଇଥିଲା ଆଉ
we have nahi, we have sought for the instruction but it has not come.
ସେଇଆ କହୁନାହାନ୍ତି ଆଉ ଆପଣ ଅଲଗା ଟାଇପ ର ବୁଲେଇ ଦଉଛନ୍ତି ନା ତ the Land and Council for the state submitted that though he has received the case diary पाइजन ना नहीं
ना case diary
sir the matter may be taken up next week in order to comply the order dated 5/7/2024 put up this matter on 2nd August 2024 yes.
Item 107.
The appellant number 2 filed the interlocutory application for Millard bail. In the meantime, Millard other two appellant also released on bail as because Millard custody near about 9 years.
But is your custody period?
Same.
Have you produced the correct custody certificate?
Arun sir.
Appellant number 2, you are filing appellant number 2.
Yes. Yes, ma'am.
What is the sentence imposed?
10 years. Same judgment, 3 persons convicted.
20B2C.
20B2C. Order
Kete hochi Mr. Tripathi?
9 years, 5 months.
Are the Land and Council for the petitioner and counsel for the state? The Land and Council for the state has produced the written custody certificate from the Superintendent District Jail Board, which indicate that the petitioner is in custody since for 9 years, 5 months, and 27 days. The petitioner has been sentenced to undergo imprisonment RI for 10 years. It is stated that similarly situated co-accused persons have already been released on bail, which is not disputed by the Land Council for the state. Considering the submission made by the Land Council for the respective parties, the period of detention of the petitioner in judicial custody, and keeping in view the ratio laid down in the case of Muhammad Muslim, I am inclined to release the appellant number 2, Arun Sahani on bail allowed. Next.
Item 110.
TP2C NDPS 10 years conviction, and out of that he has already been custody more than 5 years 7 months. And he earlier granted bail.
Custody certificate anchindi.
He also granted interim bail and he also surrendered in time, Lord. And the appellant number 2, Lord, already released on bail by this one.
This application has been filed for
appellant number 1, detention shop.
IA number 1217 to এটা ফাইল হইছি টিমসেন সাহু যে appellant number 1.
Yes. Appellant number 2 already granted bail.
Sentence is 10 years.
10 years.
Are the Land and Council for the petitioner and counsel for the state, considering the submission made by the Land Council for the petitioner, produce the custody certificate issued by the Superintendent Model Convict Prison at God, which shows that he has remained as on 13/5/2024 he has remained in custody for 5 years 4 months 23 days. আচ্ছা তাদের আজন দেখি দেবো সেই জোরটা কইছিল the same is taken on record. He further submits that the petitioner was granted interim bail ketthar jaicandi once and after availing the same he surrender at right time, and since paper book has not been prepared, there is no chance of early hearing. The bail application of the petitioner may be favorably considered. Land Council for the state oppose the prayer for bail considering the submission. the period of detention of the petitioner in judicial custody and keeping in view that ratio laid down in Muhammad Muslim, bail application is of appellant number 1, so and so is allowed. Yes. Serial. Who jaye jaitila amar? Serial. 36 jaye. That's 37.
Item 37.
37 last order that I have to submit the two local sureties. Yeah, by mistake I have not given. By Tuesday I will give. Let it go Friday.
Okay. The Hon'Ble and counsel appearing for the petitioner submitted that as per the order dated 12/4/2024, he is yet to give the names, address, and documents of two local sureties, and 1 week for the time is required for the said purpose. In case the same is given to the land council for the state, them shall be verified to achieve the order. Matter to be listed. Gote saptah tapar chhadi kin list kare. Yes.
Pardon, the address verification in the meantime.
Address,
Last order thila.
address verification to thila current.
I will obtain in the meantime.
All right. So for that, number of adjournment has been given. You just comply your part. Okay. Yes.
Item 38.
Yes.
My lord, petitioner is in custody since 5/9/2021, my lord. This is the second application before your lordship, my lord. Earlier, your lordship on 22/2023, lordship is directed to expedite the trial.
6 months.
My
So
lord.
what is the position now?
My lord, out of 26 witness, charge-cited witness, only 5 witnesses has been examined.
Status report call for itla.
No, my lord.
Acha, call for he jao. Lekon, the Land and Counsel for the petitioner submitted that even though in the earlier bail application of the petitioner in BLAPL number 4279 of 2022 as per order dated 22/2023, the Land and Trial Court was directed to expedite the trial and conclude the same within a period of 6 months from the date of receipt of the copy of the order. But only kete 5 witnesses have been examined out of 26 witnesses. In view of such submission, let a status report be called for usual order for them. Yes, matter will be listed also. Yes.
Item 39.
The second round application, Annexer 2 is the earlier bail application order. Running is 15 lordship. There in the earlier order, lordship is directed that after the examination of the leading discovery witnesses, the petitioner may renew his prayer. And
that was the order dated 8/5/23.
2023.
So how many witnesses have been examined totally?
As in the date of filing the application, that was around 7 witnesses were examined. But
you have no instruction now.
During pendency,
all right. The Land and Counsel for the petitioner submitted that when the petitioner earlier approached this court for bail in BLAPL number 11191 of 2022, the same was disposed of as per order dated so and so, and the petitioner was given liberty to renew the prayer for bail after examination of important witnesses, including the witnesses to the leading to discovery. He submits that he has received instruction that kitna witnesses
latest only 4 to 5 witnesses remain.
He is not sure how many witnesses have been examined, and let the status report be called for. And while submitting the status report, is to send the deposition copy of the witnesses already examined, and on receiving the same, one set shall be supplied to the state council, another set to the council for the petitioner. Yes.
Grateful.
Item 40.
Mr. Gupta. Next.
Item 41.
Yes, Mr. Dwivedi.
I order dated under 22/1/2024, also directed for examination of one of the eyewitness
That is Potti Godnaik.
Pati na Roti?
Sir, Potti. Actually.
Roti lekha hai.
He has already been examined as PW7.
हाँ.
I've given her his statement.
PW7.
Yes, ma'am.
କାଇଁ ଚାରିଟା ତ ଦେଇଛନ୍ତି ଆପଣ
ତାପରେ
ଆଉ ଦେଇଛନ୍ତି ଆଉ ଦେଖିଥିଲେ ଇଏ ହେଇନି ସ୍କାନିଂ ହେଇନି PW7 ବୋଲି ଗୋଟେ ୱିଟନେସ୍ ଦେଇଛନ୍ତି ଦେଖିଲ ପତି ଗଡନାୟକ ବୋଲି स्टेट काउंसिल को ଦେଇଛନ୍ତି सपोर्ट କଲାନି କି
ନାଇଁ completely
ଆଉ କେହି ସାକ୍ଷୀ ବାକି ନାହାନ୍ତି
total ଆଗରୁ ଯୋଉ PW1 to 4 ଦେଇଥିଲି
In this case, 3 eyewitnesses. Previously, they have already hostile, my lord. Jagan Naik and Satyajit Naik now.
ରହିଥିଲା ଏ PW7 ଟା ରହିଥିଲା are the learned counsel for the petitioner learned counsel for the state the learned counsel for the petitioner submitted that the petitioner is in judicial custody since kebedu
24 to 2021
24 to 2022 2021 and he has been charge sheeted under section
302 by 34 of the IPC
302 by 34 of the IPC
302 by 34 of IPC read with section 25 27 of the arms
लिखिदेले he further submits that in this case there are 3 eyewitnesses in total Mrs. Sahoo tinita eyewitness tho and
Jagan Naik, Satyajit Naik and Pati
and all the 3 have already been examined in the trial court and they have not supported the prosecution case which is not disputed by the learned counsel for the state considering the submission made by the learned counsel for the respective parties since the eyewitnesses have not supported the prosecution case and the petitioner is in judicial custody for such and such period I am inclined to release the petitioner on
8 criminal antecedent, madam.
Huh?
8 criminal antecedent.
yes madam that is on record
the learned counsel for the state submit that there are number of criminal antecedents against the petitioner however the learned counsel for the petitioner has filed comprehensive affidavit relating to the status of those cases
out of 8 members 6 acquitted 2 beyond bail
he is to appear before the learned trial court on each date and shall not try to tamper with the evidence, shall not indulge in any criminal activities, violation of any terms and conditions shall entail cancellation of bail.
Previous item, my lord. Item 40, previous item.
42, yes, 40. BLAPL 14224 2023, yes.
B2 in NDPS. This was the second journey, my lord. Earlier Lordship Director for early disposal of trial. Status report was called for.
Status report indicates that 7টাରୁ 2ଟା ହେଇଛନ୍ତି ଆଉ ପ୍ରିଜାଇଡିଂ ଅଫିସର ଜଏନ୍ କରିନାହାନ୍ତି 31/5/2023 ତେଣୁ ଆଉ ପ୍ରୋଗ୍ରେସ କରୁନି ଆପଣ କେବେଠୁ ରହିଲେଣି
From June 2021, 12/6/21.
June 21, 12 June 2021. କୋଉଠିକା ଲୋକ?
He is a man of outsider.
address verification ହେଇଛି?
No
Address verification ନାହିଁ.
ନାଇଁ ତାହେଲେ କରନ୍ତୁ ଲେଖନ୍ତୁ the period status report submitted by the learned trial court. The learned counsel for the state drew the attention of this court that the petitioner is a man from Ludhiana district in the state of Punjab and Haryana. The and seek some time to obtain instruction regarding the address verification. Let the superintendent of police Jaipur make necessary communication with the superintendent of police Wansu and obtain the instruction matter be listed on such and such date.
Yes.
Next one.